memo is placed on record and the petition is
Lord, one submission, my lord.
ಏನಾಗ್ಬೇಕು ಹೇಳಿ ಅಲ್ಲ ಸರಿ ಇವಾಗ ಏನಾಗ್ಬೇಕು ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ 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 ಪೊಸಿಷನ್ ಕೊಡಕ್ ನಾವು ಆರ್ಡರ್ ಕೊಡಕ್ಕೆ
Submission, my lord.
Memo 52. Rupesha. Declare ಆಗಿದೆ ಇಲ್ವಾ? You are for the petitioner. Counsel for the petitioner submission to the parties have settled that the certificate will be reported on 29th March. Day of the process is on 29th March.
ಎಲ್ಲಿಂದ ಬರ್ತೀರಾ?
Cinema 38. On the ground of the law, to argue this petition and has some increase in this post. This for CH-20.
Serial number 17, your lordship.
17. What do you want?
17, your lordship. I am suffering from high fever, your lordship. Kindly have the matter day after, your lordship. I am suffering from high fever, your lordship. Yesterday also I took time, your lordship.
If you are suffering from high fever, why are you wearing a black coat?
My lord.
You are sitting in the office.
No, your lordship.
You are sitting in your office, mister. Don't say no. You are sitting in your office.
My lord, I am really suffering from high fever, your lordship.
Counsel for the petition. Please intimate the other side.
Day after tomorrow, your lordship.
The number? Counsel for the petition. Please intimate the other side. Sure. They want to extend to the next. Sorry, mister. No 2 weeks. Counsel for the petition. Please extend to the next. This one. The number? Request your land counsel for the petition is found. That's in the orders list. The number? Wait. All your cases are adjourned. There is only one case left. Movies come money. How about 4 o'clock? Number? Well, counsel for the petition this time on the ground that the arguing counsel will be disclosed. This not. For the exchange to the next. 58. Sorry, madam. 2017 no adjournment. ಅವರಿಗೆ ಅರ್ಥ ಆಗುತ್ತಲ್ವಾ? ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಇರೋದನ್ನ ಮೂವ್ ಮಾಡಬೇಡಿ. ಈ ಕೋರ್ಟ್ ಅಲ್ಲಾಗ್ಲಿ ಹೈಕೋರ್ಟಿನ ಯಾವುದೇ ಕೋರ್ಟ್ ಅಲ್ಲಾಗ್ಲಿ ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ದಯವಿಟ್ಟು 10:10ವರೆಗೆ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳಬೇಕು. You should wait for your turn. Finally, ಯಾರು ಅದು ಆರ್ಗ್ಯೂ ಮಾಡಿ ನೀವೇ ತಾನೆ ಇವಾಗ ಯು ಆರ್ ದ ಒನ್ ಹೂ ಇಸ್ ಲುಕಿಂಗ್ ಆಫ್ಟರ್ ಹಿಸ್ ಆಫೀಸ್. Counsel for the request for adjournment is made on the ground of the counsel for the petitioner is no more. By the last chance discount 21st. Yes. And while adjourn it, but no extension. No extension. What do you want? Interim order will not be extended. 2016 petition. 7 years have gone by. Please argue. This lawyers from the VC, they request for adjournment. Correct. Please pass it on. Why? For what? Yeah, for tomorrow. Yeah, being spoken to him. ಏನ್ ರಿವ್ಯೂ ಮಾಡಕ್ ಬರುತ್ತಾ? ಏನ್ ಮಾಡೋದು? Forgery is fair enough, but can I review it? Yes, sir. That review. ಏನ್ ಮಾಡೋದು? Take it in appeal. Take it to Supreme. Yeah, no, I cannot. There's an express bar. Sentence here or within is an exception to sentence. Judgment okay. We'll uphold the judgment of conviction. Sentence here or can the sentence be altered? Find out the law, Mr. for sentence. How can I exercise 482 sitting in revision? Find out what is the law regarding sentence. Can the sentence be altered after the disposal? Counsel for the petitioner sees time. Discount. Signature tally. The size of memo of retirement, signature is not tally. Rectify ಮಾಡದಲ್ಲಪ್ಪ. ಮೆಮೊ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಕ್ಲೈಂಟಿನ ಹಸ್ತಾಕ್ಷರ ಮತ್ತು ವಕಾಲತ್ತಲ್ಲಿರುವ ಹಸ್ತಾಕ್ಷರ ಬೇರೆ ಬೇರೆ ಇದೆ. ಅಪೆಲೆಂಟ್ ನೀವು ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಬಿಟ್ಟು ಅಪೆಲೆಂಟ್ ಸಿಗ್ನೇಚರ್ ಮಗನ ವಕಾಲತ್ ಎಬ್ಬೆಟ್ ಹಾಕ್ಸ್ಕೊಂಬನ್ನಿ ಏನೋ ಒಂದು ಮಾಡಿ, ಬಟ್ ಯು ಕಾಂಟ್ ಮಗನ್ ಸಿಗ್ನೇಚರ್ ಹಾಕ್ಬಿಟ್ಟು ಅಪ್ಪನೇ ಯೂನಿವರ್ಸಿಟಿ ಕೊಟ್ಟಿದ್ರೆ ತಗೊಂಡೋಗಿದ್ರೆ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತೀರಿ? And you mislead the court also. You don't even tell when the order is passed that the signature is that of the son, not of the appellant. The learned counsel for the petitioner submits that the signature of the son of the appellant is found on the memo of retirement. And therefore, memo of retirement and not the signature, and the appellant has not signed the memo since he is unwell and is hospitalized. So in view of the above, the order dated 3/3/2023 need not be given effect to, and office is directed to continue to show the name of Mr. D.L. Jagdish and Omkaresha in the cause list. Non-receipt of investigation report from the jurisdiction to Bharat. Huh? This data board. Copy product. Have a look at the order. This is after receipt of the investigation report. Making arrangement for representing the Jadhav. What's your name? Chetan Jadhav. What's your name? Mr. So-and-so submits that Mr. Chetan Jadhav would enter appearance for the petitioners. They not file the wakalat. Stop. If the wakalat is filed, office is directed to show the name of Mr. So-and-so as a counsel for petitioner in the cause. List on 20th. Still number 4, the interim order is continued to the next meeting. 1 week time is granted to do the need. Stop. The interim order granted is extended. If the process is not paid within 1 week, the interim order process is not paid within 1 week, and if the other requisites are not deposited, the interim order extended today shall stand automatically dissolved. Please ensure that everything is in order, Mr. Office objection why the interim order. This is the IA 1 of 20. Office is referred an advocate for R2. IA 1 of 20. So vacating state. We received a copy of this. There is no representation for the respondent number 2. In 6 and 6.1. 6 on 6, 6.1, 6.3. Hence list on so and so. In the meanwhile, the process is 6.2. In the meanwhile, the process and other requisites shall be deposited within 1 week. Failing which the petition against R2 shall stand. Whether the same lawyer appears for the other respondent also. In 6.2, who is this respondent number 2? Timma Rajachar. Mr. Ramurthy represents him. All the cases. There is 6.2 million. Mr. B.C. Ramurthy directed to accept notice for respondent number 2. List on 21st March. Interim order is extended to the next step. Saravana? Why? 1 week time is granted to do the need, dealing which, petition shall stand dismissed without reference to bench. 2 days time is granted at the request of the land council for the petition to do the need. Police report along with the death certificate of R2 is R2 complainant. What is the claim? Yes. Yes. Correct one. Complaint is dated. So what happens? Does not appear. The police report along with the death certificate of R2 is produced. In view of the death of the respondent number 2 / complainant. The proceedings do not abate. Yes, yes, charge sheet agidya. Charge sheet is filed. List the petition for admission on date put. Prasad BS. Charge sheet agidya. Yes, madam. You come up for admission. 1 week time is granted to do the need. Dealing with the petition against respondent number 2. Office objection raised in A1. This A1 of 2011. Who has filed this application? Any objection? IA1 of 22 is filed by the son of the complainant to come on record. It is stated in the affidavit accompanying the application that the complaint has expired and therefore, his son desires to come on record and contest the proceedings. The joint counsel for the petitioner has no objection for allowing this application. In view of the same, IA1 of 22 is allowed. The applicant is permitted to come on record as respondent number 2. So, counsel for the petitioner is granted to amend the first statement and file an amended first statement within 1 week. What is IA2 of 20? Interlocutory action to the next state of the list on. Don't move an orders matter. ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಮೂವ್ ಮಾಡಿ ಬಯಸ್ಕೋಬೇಕು. ಆರ್ಡರ್ಸ್ ಇರೋದು ಕೋರ್ಟ್ ಅವ್ರು ಮಾಡೋ ಕೆಲಸ ಅದು. ಇಟ್ ಇಸ್ ನಾಟ್ ಯುವರ್ ಜಾಬ್. ದ ಜಾಬ್ ಆಫ್ ದ ಕೋರ್ಟ್. ಕೋರ್ಟ್ನವ್ರು ಮಾಡ್ಬೇಕು. ಐಎಗಳೆಲ್ಲಾನು ನಾವು ಇತ್ಯರ್ಥ ಮಾಡ್ಬೇಕಲ್ವಾ. ಹಂಗಾಗಿ ಅದು ನಾವು ಮಾಡೋ ಕೆಲಸ. ನೀವು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಹೋಗ್ಬಾರ್ದು. ಅರ್ಥ ಆಯ್ತು. ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಮಾಡಬೇಡಿ. ಫ್ರೀ ಅಡ್ವೈಸ್. Your Read the process. Counsel for the petitioner, but the needful is done. If the process is in order, command office is directed to issue notice to the respondent. Yes. Huh? Yes, madam. Correct. In the notice is servagvetala. The notice is to be served yet. So once the notice is served, we'll take it up. Subhash Chandra Bose. 1 week, there is no representation for the petitioner. 1 week time is granted to do the need. Clearance case, EA 1 of P2 for modification. What modification? Modified order dated 23/6/2015. 2015, you are seeking to modify it now. What is the release of this amount? That money is already gone. Correct. The currency notes have lost value now in view of demonetization. Demonetize ಆಗೋಗಿದ್ದಿಲ್ಲ. Huh? That is what is taking over. Yeah. Correct question. What is there to show that you're taking on?
Share certificate number page number 16.
Yeah.
Page number 6.
No, if you merely purchase the shares, that will not suffice. Where is the agreement taking over the company? Just because you purchase the shares, you don't become the owner. Who are you? Correct. If a company has taken over another company, there should be corresponding agreements. I see. The incorporation change agidya. For the petitioner. For the petitioner seems time to applicant to place and record documents to indicate that the petitioner is taken over by the applicant company. Is on. What is it? What is the contract? If that is the case, what should we do? How is the criminal case? What is there to show? Vasi Infra Developers India Private Limited.
Private account saying that it's a company.
Correct, but You are supposed to pay the money to Vasi Infra developers. Is there any process for arbitration or something? No, close is there a possibility to settlement? Huh? Learn counsel for the petition respondent to time to explore the possibility of settlement case. No. Hmm. Then get what is this change of land? You should go before the appropriate court. The registry is directed to peruse the order dated 23/6/2022 and place this petition before the appropriate court having roster. Planning order. Correct. All our court is interim order granted release. Madhukar Nadik. November 18. Even the Karan to be around. Number 18, number 19. Where is the complaint? In page number 18. What?
his own allegation that not happened to them. To that. Maybe what many jealous. The event has been given to the now CG police has
Settlement ಯಾವ ಮಾಡ್ತಿದ್ರು? Correct. So when will pay his money back? Pay his money. Pay his money back. 6 years have gone by. Like ಯಾವ settlement, these are genuine transactions. Let people have some faith in the institution. No, that will be closed. It should not be as if High Court is aiding people who are avoiding the law. What has happened to the case? Check ಅರ್ಧ ಕೊಟ್ಟಿದ್ರಲ್ಲ 130 ಇಟ್ಟಿಲ್ಲ. You already torn off the check. It is for 5,80,000. 5,80,000 rupees. 6 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಇಸ್ಕೊಂಡು ಚೆಕ್ ಅರ್ಧ ಕೊಟ್ಟಿದಾರಾ? ಯಾವಾಗ ಹೇಳ್ತೀವಿ? 15 days ಎಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ. Learn counsel for the petitioner seeks time to explore the possibility of the settlement. So genuine transactions. So if there is a genuine transaction, please tell your client to honor it. ಆಯ್ತು 2017 ಇಸ್ವಿಯಿಂದ 6 ವರ್ಷ ಟೈಮ್ ಸಿಕ್ಕಿದೆ, let him honor it. Yes. 20th March. Charge sheet is filed by the No. Who has filed the charge sheet? CCD. Pending before the whether it's a police station or not. No, but this court has taken a view that it's not a police station. This court has taken a view. It is for the internal inquiry by the police. Ultimately, the charge sheet has to be filed by the police. 2S, section 2S ಆಗ್ಬೇಕಲ್ಲ. You don't qualify to be a police station in section 2S. ಯಾವ 20th. Number 20. Yes, master. Covered. Petition is allowed. Consequently, the proceedings initiated against the petitioner with CC number on the file of he is accused 1, 2, and 3. Are there any other accused? Fourth is abated. One. So Venkatesh Prasada. Yeah, Venkatesh Prasad. You are Venkatesh. Learn counsel for the petitioner seeks time. Interim order is there. Learn counsel for the petitioner seeks time on the ground that is unwell. This time, Mr. Tajuddin. Keshav Kumar. What is the case about? What is the case?
We are examining this. We not the exam.
Where is the application? 311, that is right, that is a provision. Where is the application in the file? Page number? Yeah, first. What is the stage of the case now? The stage of arguments is up. At the stage of arguments, his application was filed.
This is the document. He acts directly there. Running, discovering how she is working, he only makes up some kind of comments. But he does not reveal. That is the meaning of the. You can find.
What is the original proceeding? Is it under the DVI?
Yeah, some.
Summary proceeding are there?
Same money.
This business of anger is undertaken. The boutique. This is undertaken by this petitioner or the respondent.
I have produced by way of
This business is undertaken by the respondent.
my friend has gone to this job and he has elected all these people. Was there, he is also present. Business was going on.
What is the claim made? Claim is
To demonstrate.
sir. What is the claim made for sir in the domestic violence case? Has she sought for maintenance? Let him complete. Let him complete. Yes.
Yes, right, maintenance, the DVA.
That is rejected. Where is the petition under the DVI? The final prayer is to direct the respondent to pay monthly maintenance. There is a claim for maintenance also. Sir, here the case has reached the final stage. Correct. So the court will have to decide whether she is entitled to maintenance or not. Yes, Mr. It's the fact that the interim applications were
Still pending consideration.
but why did the court say to take up at the final stage, final hearing? Interim application has to be disposed of the interim stage. Why?
Because there was clause 16 letter to say that it's part of applications for it.
Correct. After notice, why was it not?
That's what.
Why?
It's still being used.
Now that he has got some material, you tell us, we'll fix one date for cross-examination.
There's a paragraph shift in more than applicable cases in view of location and layout.
Huh?
Ratio should be here. Litigation. But things are supposed to be clear. Because I'm, in this case, was if there is any kind of one of the
So who has to point out the mistakes or the
source is not up to the
who has to point out that there's a mistake in the disclosure?
there are socially compensated guidelines about the game. First, they have data invoke for evidence. There's absolutely clear evidence. So this case of
Point out what is the remedy? This point.
the relation should be able
Point out what is the remedy according to you?
People has to be provided so that people have to do.
Right, assets and liabilities have to be submitted, no dispute. So he wants to establish whatever assets and liabilities that you are given is not correct or you suppress some material. So he wants to establish. That is only after the trial is completed. Please read out. Forget the disclosure. If there is any mistake in the disclosure, how do you deal with that? Has that been mentioned in Rajneesh versus Neha?
The declaration says, because
Taking judgment to do. Please give him the citation. Yes, what is it? Correct. How should he prove that the disclosures made by you is incorrect?
I undertake that my cost statement. This. From being. So. So, I was section 4, they do for permission to for 2 years. Then, yeah, that is good.
Who has to?
What the difference says. The opposite party has been given. They need to interpret the person who is fighting.
So now he has come out with some new material. So why he should not cross-examine you on that?
He has so something by your not law and
What question?
in terms of how the application is made, what But logic can answer this.
So we are dealing with an application section 311. Now, the question is whether an opportunity should be given to him to cross-examine you or not. That is all. His request is based on some material that he has collected. So what is the prejudice that will be caused to him?
Cross-examination is not open, but he says that I want to come to
What is wrong in that? What is wrong in making such a request? Please read.
That is, the order of 73
Yes.
What is that liberty of this order? One needs to this needs that in the I guess then our response has created with the name of the friend anywhere in the we have restored to the customer. Frequently, in the entire affiliate, the reason for recording is the same friend or customer will this one just to be but the act of giving creates doubt and willingness of what happens, how the response is going to execution going forward. That is not connected to the relevancy of the state education of this. What are the who will go this. See, this also. The medicine. By the giving of the reason.
Para? Para 9. Please read.
The inner pressure in the review order has observed that the respondent has stated that he has. She claims.
Please read, now read para 10. Please read para 10.
Looking to tax decisions as a same opinion as she makes forms of fiction. In this regard, it is also necessary to look the portion and how the because evaluation
You have wasted 6 years before this court. You wasted 6 years before this court. Correct? So that you could have asked the court to go on with the cross examination or the additional chief examination and be done with it. 6 years are wasted. Here is the application for.
I also made application for
Read. Where is the application? Sajuddin, where is the application? 311. Yes, when will you examine yourself? We'll fix a date. With 65D certificate. If the certificates are not in order, you will not be given further opportunity. And you cross-examine on the same day. So one day.
I think clearly on the parents of proceedings cannot be solved even after the meeting, then
Petitioner has challenged an order dated 16/8/2016 passed by the Metropolitan Magistrate Traffic Court -3 Bangalore in criminal miss 233 of 2013, by which an application filed by him under section 311 of CRPC to recall him to lead further evidence was rejected. The petitioner has also called in question the order dated order dated 20th July 2017 passed by the 55th Additional City Civil and Sessions Judge, Bangalore City in criminal revision petition 700/2016. Next paragraph. The respondent herein initiated filed a petition under section 12 of the Protection of Women from Domestic Violence Act 2005, bracket henceforth referred to as Act of 2005, bracket close, seeking for a protection order under section 18, a residence order under section 19, and an order for monetary relief under section 20 of the Act of 2005. Full stop. This petition was opposed by the petitioner hearing. Full stop. The petitioner and the respondent had filed their assets and liabilities and thereafter went in for trial. Full stop. After the evidence of the petitioner hearing was recorded and he was cross-examined by the respondent, and when the case was set down for arguments, the petitioner filed an application under section 311 of CRPC to recall his evidence fully and to lead further evidence in view of certain new information dug out by him concerning the business establishment of the respondent herein and the income generated from the business. Full stop. The trial court rejected the application on the ground that the petitioner was unnecessarily protracting the proceedings. To start, a revision petition filed by the petitioner before the revision court was also, before the district court was also, before the sessions court, sorry, before the sessions court was also rejected. Being agreed by the same, the present petition is filed. Next, the learned counsel for the petitioner submits that the respondent was duty bound to disclose her assets and liabilities, and also the business undertaking established by her under the name and style, Hanger, which is a boutique. Full stop. He submits that the petitioner had to physically go to the shop. He submits that his friend had to physically go to the shop and make purchases. Stop. He submits that the CCTV recording in the shop, outside the shop. What was recorded in the CD, Mr. That a spy camera, that the friend of the petitioner wore a spy camera on which the transaction between the respondent and his friend was recorded. To stop. He submits that the petitioner had filed appropriate application under section 65B of the Indian Evidence Act. And that this was a material piece of evidence to establish that her affidavit filed with support, affidavit filed disclosing the assets and liabilities was incorrect. Full stop. In which court? Here. So, therefore, submits that an opportunity be granted to him to establish that the claim of the respondent that she has no source of income is false. Full stop. Per contra, the learned counsel for the respondent submits that the order passed by the trial court discloses the way in which the petitioner is protracting the proceedings. Full stop. He further submits that the petitioner had deliberately not disclosed the details of his friend who went to the shop, who allegedly went to the shop in question and who made some purchases at the said shop. He submits that this was a crucial fact that had to be disclosed, without which, the trial court was not required to show any indulgence to permit the petitioner to lead further evidence. To stop. I consider submissions made by the learned counsel for the petitioner as well as the learned counsel for the respondent. Next paragraph. The petition under the Domestic Violence Act 2005 was filed in the year 2013. Full stop. The proceeding, the trial in the case was concluded and the case was listed on what date? Listed on when was it listed for argument? The main petition listed during, please give us the date, Mr. Listed on dash for to address arguments of the petition, on the main petition. However, at the fag end of the proceedings, the petitioner filed the instant application under section 311 CRPC to examine him further on the ground that he had unearthed some material documents which established the business set up by the respondent. So the documents placed on record disclose that, sorry, the documents placed along with the application under section 311 of CRPC discloses that a person named Savira. Exhibit P46 ಅಂತ ಮಾರ್ಕ್ ಆಗಿದೆಯಲ್ಲ ಇದೇನಿದೆ? Then why did you not produce it at the earliest stage?
I discovered that he.
Okay, so this document that you have sought to produce along with this application is already marked as an exhibit in some case. Where is the original of this?
All are certified copies.
ఏమైతే? Savira had made some purchases at a shop, at a boutique. Savira. He is the respondent. Named Savira had made some purchases from Hanger the boutique on 19/4/2016. Saira. SAIRA. SAYRA. Saira. A CD containing camera recording. CD containing the recordings of a spy camera was also placed on record. Full stop. Similarly, a CD containing audio track of a conversation at the business place of Hanger the boutique was also placed on record. Likewise, a CD containing photographs of the business conducted by the respondent at Hanger the boutique was also sought to be placed on record. Full stop. Since the respondent claimed in the petition filed under section 12 of the Act of 2005 that she has no source of income and that she had filed a list of assets and liabilities which indicated that she did not have any source of income. The material now sought to be placed on record. Prima facie indicates that the respondent was indeed undertaking some business or was employed at this said business. Full stop. It was therefore appropriate for the trial court to have allowed the petitioner to need further evidence by appropriately marking these documents, marking the documents sought to be placed on record. To stop. The approach of the trial court in refusing to entertain the request for further examination in chief is incorrect warrants interference by this court. In that way of the matter, full stop, next para. The petitioner, the trial court has found that the affidavit, that the certificate filed by the petitioner under section 65B does not conform to the requirements of the Act of section 65B of the Indian Evidence Act. Full stop. The petitioner, therefore, is bound to file appropriate certificate if he desires that the electronic evidence is taken on record. That way of the matter, this division petition, this petition is allowed. The impugned order passed by the trial court and the appellate court, the divisional court, are set aside. The application filed by the petitioner under section 311 of CRPC is allowed. The petitioner is permitted to adduce further evidence subject to he filing proper certificate under section 65B of the Indian Evidence Act, which is acceptable to the trial court. Stop. In order to enable the petitioner to produce further evidence, yav is the next step. He shall without fail adduce further evidence on 15/3/2023, and the respondent shall also cross-examine him on the same day. The trial court may consider disposing of the original proceeding within a period of 3 months from the date of the conclusion of the within 3 months from the date of conclusion of the evidence of the petitioner. So now we have reached the fag end of the proceedings. And how did you survive for the last 6 years? How did you survive for 6 years? The petitioner fails to take advantage of the indulgence shown by this court by not examining himself on 15th March 2023. The trial court is at liberty to dispose of proceedings based on the available material. Yes. Even there are no. You always used to standing on this side, is it? Yeah. Naibala don't consent. Yes, please.
This is the order passed. The tendency of the appeal filed by the assessee for the trial is disposed. If that order, and is that the adjudication proceedings have a bearing on the outcome of the prosecution. And the prosecution should be stopped till the adjudication is completed. On that premise, the application is filed. It's the complaint filed for the offense punishable under section 9 of the sentence. The first order is passed, the adjudication is confirming that there is an evasion, maybe in penalty, etc. So that is a challenge by the respondent. Now the respondent is 20 or even more than that appeal. Now they have not seen the light of the day.
Mr. That you should expedite, get it expedited. The adjudication proceedings itself is in question.
Adjudication order is in question now.
Then it be independent.
Some judgments say that it is an independent, but however, the result of the adjudication has a bearing on that.
It is subject to the outcome.
Subject to the outcome of the phenomenon.
Ultimately,
It has some relevancy in litigation. So it is. Criminal proceedings do not depend on the adjudication.
Right, but the adjudication proceeding is the subject matter of an appeal.
Okay.
So therefore, why should criminal proceedings go on?
At least ನಮ್ಮ evidence ಮಾಡಕ್ಕಾದ್ರೂ ಬಿಟ್ರೆ that question we will at least cover ಅಂತ ಹೇಳಿದ್ರೆ question I think
Let the evidence go on. Judgment will not be pronounced.
Judgment will not be pronounced.
Let the proceedings go on.
There is a city
The assistant chairman is not here. But how can you give an undertaking that this should be disposed of within 2 minutes?
That's what I'm saying. But my intention is
And the court has merely adjourned it. That's it.
ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ವಿಟ್ನೆಸ್ ಇರ್ತಾರೆ.
This is a statute.
But you again witnesses will not get them. These are all the time allowed to
Let the trial go on. If he wants to conduct the trial, let him. Tonight, that is not before this. That is not before this. When was the adjudication order passed? 2012, 23.
CC that we tomorrow, I guess. The prosecution,
Kept over this matter for almost about how many years? 6 years. ಮತ್ತೆ 2-3 ತಿಂಗಳು ಏನಾದ್ರು
observation what is to
petitioner has challenged an order dated
order dated 14/10/2016.
14/10/2016.
CC number
Passed by the
Special Court for Economic
Special Court for Economic Offences in CC number 103 of 2014, by which an application filed by the accused under section 309 of CRPC was entertained. The case was adjourned sine die in the disposal of the appeal filed by the accused, challenging the order of adjudication before the sestat. Next paragraph. The petitioner passed an order of adjudication, adjudicating the central excise dues allegedly evaded by the accused. What is the date of the order?
31/7/2012.
31/7/2012. Following which, the accused filed a statutory appeal before the central excise, before the sestat, Bangalore, in what is this? E/2882/2012. Is the order of adjudication stayed or something like that? Stop. The tribunal had passed an order of stay of the order of adjudication passed by the petitioner. Stop. Notwithstanding the order of stay and the pendency of the appeal before the tribunal, criminal prosecution of the accused was initiated before the Special Court for Economic Offences. Full stop. The accused therefore filed an application under Section 309 of CRPC requesting the trial court to postpone the case until disposal of the appeal before the SESTAT. The trial court, after considering the request of the accused to be just and reasonable, allowed the application and adjourned the case till the disposal of the appeal before the SESTAT. Next paragraph. The learned counsel for the petitioner submits that an order of adjudication submits that the impugned criminal prosecution is based on the order of adjudication. The learned counsel for the petitioner submits that the impugned criminal proceedings arises out of an order of adjudication. I'm reading from your complaint only. In complaint in the arises out of an order of adjudication, which is an independent order, which is independent of the outcome of the proceedings. He submits that the accused, having not complained with the order of adjudication, is bound to be prosecuted. Per contra, the learned counsel for the accused submits that an appeal before the SESTAT is provided under the Act, and the tribunal has stayed the order of adjudication, which indicates that the order of adjudication is not enforceable, and therefore, no purpose would be served in continuing the criminal prosecution until the appeal before the SESTAT is disposed of. He therefore submits that the trial court had rightly allowed the application and had postponed the proceedings till the conclusion of the appeal before the tribunal. Next, I consider submission made by the learned counsel for the petitioner as well as the learned counsel for the respondent. As rightly contended by the learned counsel for the respondent/accused, when the order of adjudication passed to the petitioner is in appeal before the appellate authority, where the order of adjudication is stayed, the petitioner could not have taken any further steps to enforce the order of adjudication, more particularly by initiating proceedings before the trial court. The trial court has therefore rightly considered the request of the respondent and has rightly adjourned the proceedings till disposal of the appeal before the tribunal. There is no error warranting interference by this court, hence this petition is dismissed. The tribunal is requested to dispose of the proceedings as expeditiously as possible, Vachita Nanaya. For vacating, offense. What is the offense? Petitions are? That's all.
But according to litigation, the one to four on the other. But if you talk about one or two are running the case. I think in the case of the- I don't know the- but I think in the-
What is that?
Either
Yes.
during the course of investigation,
Please come to section 15 of that. Ah,
the irrigation flood at 20, 11, 15.
page 20. Aesthetic saloon and spa.
This is the complete.
One thirty.
Okay, then you have to
Page 22. ITP Act.
in Karnataka, DRL was stated in the Human Constitution. 30/70/2020 decided in first October 20. I read this now. Examine whether or not the ratio in the interest of litigation rate is not. Not if it is critical or secret information and what happens. They go to the. I know taking such other measures, we should but focus is on the easier. The information data of that situation. Thereafter, we a report which may be treated as FIR or other course of action. Sometimes offense to
No, just in case of Lalita Kumari, the court has said that a preliminary inquiry can be done to ascertain whether a cognizable offense is committed or not. But if there is a credible information that a cognizable offense is already committed, then he has to register a FIR, register a crime, and thereafter take up investigation. But to ascertain whether a cognizable offense is committed or not, a preliminary inquiry is permitted.
Inquiry and investigation.
Yes.
This is a case where investigation is
Yes. Let us read the entire complaint if you want. What?
This is the ILR 19 from 33. ILR 2013.
But why should we look at this judgment when this judgment is based on Lalita Kumar? We look at the judgment of Lalita Kumar only. Right, it is referred. Then why see this? You see the original judgment itself. 2012 part 4 ACC page 1. 2012 part 4 ACC page 1. As of now, the judgment of the Supreme Court in Lalita Kumari still stays. Right, it still stays. It is not disturbed. Preliminary inquiry. Preliminary inquiry. Correct. Correct.
Yes.
There is a arrested made. By different. Also different categories. But this is not mentioned in some. I will pass on the status of the hospital.
What is this record of reason? Kama jarigi seen and Odi. Record of reason was. Whereas the complaints of this shall call upon two or more respectable inhabitants, at least one of whom shall be a woman of the locality, in which the place to be searched is situated, to attend and witness the search, and may order. Whether that has been complained with or not. Then.
Cannot be shared at the series.
Let us see 462. What vitiates the proceeding here? What does not vitiate? What?
The course of investigation nearly were not following the.
Let us see which vitiates the proceedings. 461. Issues a search warrant for a document, parcel, or other thing in the custody of a postal telegraph authority. Demand security. This cancels the government. And the 370 invoke in the material. 370. Huh? How? 370 king. What is the punishment under the ITP Act? ATP again. ಎಷ್ಟಿದೆ punishment? B 4 and 7 ಇದೆಯಾ? What is 4? ಇದಕ್ಕೇನಿದೆ ಮೆಟೀರಿಯಲ್ 4 What is the material collected? Section 7 ಹೆಂಗ್ ಅಪ್ಲೈ ಆಗುತ್ತೆ? It's not carried out in a public place. ಯಾರು ಪಂಚಾಯಿತಿದಾರರಾಗಿ ಸಹಕರಿಸುವಂತೆ ಸಾರ್ವಜನಿಕ ಮಹಿಳೆಯರನ್ನು ವಿಷಯ ತಿಳಿಸಿ ದಾಳಿ ಮಾಡಲು ಸಹಕರಿಸುವ ಮಹಿಳೆಯರು ದಾಳಿ ಸಮಯದಲ್ಲಿ ಇಷ್ಟವಿಲ್ಲವೆಂದು ಹೇಳಿ ಸಹಕರಿಸುವುದಿಲ್ಲ. ಅದರಲ್ಲಿ ವೀಕ್ಷಿಸಿ ಕಾಯ್ದು ಇದಾದ್ಮೇಲೆ ರಿಕವರಿ ಏನೇನಾಗಿದೆ? ಏನು ಅಷ್ಟೇ ಆಮೇಲೆ ಎಸ್ ಸರ್. Sure. Please read the four conditions. Yes. ಏರಲ್ಲಿ ಇದೆಯಲ್ಲ ನೋಡಿ, ಲಲಿತಾ ಕುಮಾರ್ SCC ನಮ್ಮಲ್ಲಿ 2012 ತಗೊಂಡ್ರಿ. 2014 SC ಕೊಡಿ. 2014 SC 187. Yes sir, please read this. ಅದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರೆ ನೋಡಿ, ಜಡ್ಜ್ಮೆಂಟ್ ವಿಚ್ ಯು ಗೇವ್. ಇಲ್ವಾ ಬೇರೆ ಕಾಪಿ ಇಲ್ವಾ? ಕೊಡಿ ಕೊಡಿ.
Anyway. That this was the site. Every case, after the police came back. The case, they remember again. Yes. The next thing, did not in the movie scope. Any special version. I think officers what will get. It's a you get to the second point is before the board also very interesting. The police were involved in the result of the government of that. Without registering the case, in this context, the next on based on letter command case. Here's discussion. The expert. So what I think which just of preliminary inquiry is the expected. Yes, the credit of places which preliminary inquiry may be held on in the criminal dispute. After lesser, critical negligence lesser, lesser. Is the way there are delay natural increasing to prosecution but delay yes, you have the above direction. You look at the police. Who would have proceeding to any other therefore before
Yes, Mr. Yes. This is a cognizable offense, so you should have registered a crime. Why did you not register? Yeah, good. Good.
we didn't do it.
was the offense in this case? NDPS. ಮತ್ತೆ NDPS ಗೂ ಮತ್ತೆ ನೀವು immoral traffic in NTP ಗೆ ಹೇಗೆ ಕಂಪೇರ್ ಮಾಡೋದು? The act of any a person possessing itself is a crime. Correct. The fact of him possessing itself is a crime. So if your ACP has got information that some brothel is being run in a spa, then what prevented you from registering a case?
That information got false.
Genuine or not?
This is
Yes. Is there any case pending? But what prevents you from registering a crime in your police station and thereafter take up investigation? Moment you get information, register an FIR and thereafter take the steps. Huh? No, ಮಾಡಿ FIR close ಮಾಡಕ್ ಬರಲ್ಲ. Correct, at least you should register a crime saying that this is the offense information received.
This is not mentioning the dairy itself is option.
ಆಯ್ತು ಡೈರಿ ಎಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು? I will mention that in the dairy, station of dairy. Please get that. Let us see. If you mentioned that in the station of dairy, and if you have said that to verify the authenticity of the information, you have gone there with the Tulsi. Yaವಾಗ?
Yes. 1980. See the rest. For the delivery. The police. Just they don't die.
There's a reference to that in the. There's a reference to that in Lalita Kumar. For example, suppose if preliminary inquiry has to be done. If a preliminary inquiry is to be done, then they can enter that in the station house dairy, take steps for conducting a preliminary inquiry, and thereafter take a decision to whether to register a crime or not.
And what other that's all right.
Let him get the station house dairy. Learn the HCGP 6 times to secure the station house dairy in respect to the offense in question. It's on 13th. 13th. Yes. Entry order granted is extended to the next 15. A for Koshman. ಅಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್ ಆಗಿರುತ್ತಲ್ಲ ಮಾರಲ್ ಕನ್ವಿಕ್ಷನ್. Will adjourn it, but no extension of interim order. Good. Council for the petition seeks time. The petition is filed in the year 2017 as the last chance response form. Suyog, Suyog. Speak. Password. Those Nagarale. Yes. 2, 6 and 7. Yes, they expect so that they're independent. The accused number 2 is a whole-time director, independent director. The whole-time director. What about accused number 2? Petition number 1. What is the offense alleged? 38. Sir, who applies for the Universal Freight Limited? ಎಲ್ಲಿದೆ? Extract ಎಲ್ಲಿದೆ? What is there to show that you are independent director? Vandana Singla. Is the allegation against them? Number 4. So why don't you serve the learned counsel who are represented responsible for the trial? The respondent is absent. The petitioner is learned counsel for the petitioners. Is directed to serve the learned counsel who represented the respondent before the trial court. This time, implement is extended to the next day. It is Prashant. Prashant HS password. David Narasimhan. Jayant Venkatraman. What is this? Where's the complaint? Parallel 2. Yes, please read. ವಿರೂಪಗೊಳಿಸಿದ್ದು Any civil disputes between the parties? Yes. Who? Filed by whom? Was this PK Jayakrishna Gowda? Is the complainant. What happened to that? The suit was decreed. It is confirmed. The suit for declaration.
Same allegation is can be taken under second application is non I am unable to accept the submission of the Sakshi and others will be based on their
The suit property.
This is right. This is incident happened on previous. So here,
Here the civil suits are not in respect of this server number. This Mr. You have taken adverse order in another case. Spot causes. Please come to page 107. Hmm?
So there, the state of Page number 97. Station of the fire.
What is the reason for delay? Great. Please read 103. ದಿನಾಂಕ 14/3/2015 3 ಗಂಟೆಗೆ ಫಿರ್ಯಾದಿಯು ಠಾಣೆಗೆ ಹಾಜರು ಮಾಡಿ ಕೊಟ್ಟ ಮೇರೆಗೆ ರೆಸ್ಪಾನ್ಸ್. Correct. But when did you submit the complaint? But what is there to show that you lodged a complaint on 25th itself? And what is the signature on the left hand side of 16(3)? What is that? Who has received this on the left hand side? No, whatever it is, what is there to show that you registered from lodged it on 25(2) itself? Nothing. Not. Ifs and buts is okay. Fact is the offense occurred on 25(2). Therefore, delay should be explained. What is that to explain? Yes. Delay in filing FIR. We are not on that. Delay in filing FIR is different. Delay in lodging the complaint. What is asking the court? The charge sheet. What does the charge sheet contain? The charge sheet contains a date as 14/3. How can you disown that? We will allow this. The petitioners have filed this petition. Challenging cognizance counted or not? The cognizance taken. Filed challenging the cognizance taken by the so and so court in CC number 99 of 2017 of the offences punishable under section 143, 425, 447 and 149 of IPC. Next paragraph. The case of the prosecution is that the respondent number 2 submitted a complaint, submitted a written information to the jurisdictional police that the accused illegally entered their land on 23/2/2015. His land, sorry, illegally entered his land on 23/2/2015 and committed depredations on the land by using a heavy earth moving equipment. Respect of which, the complaint was lodged before the police. Later, on 25/2/2015, the accused visited the property of the complainant and the complainant in a JCB, in a earth moving equipment, and they got along with them a group of people who formed an unlawful assembly and tried to enter the property of the complainant bearing survey number 98 of Teganahalli, Kasaba Hobli, Karnataka Taluk. Full stop. In that regard, he had lodged a complaint, and that the jurisdiction police had conducted a spot inspection. Later on the same day, at about 2:30 p.m., the accused again formed an unlawful assembly and entered the coconut plantation of the son of the complainant in survey number 103 of Teganahalli and put up and lit up a coconut tree by using petrol. Full stop. The complainant is stated to have informed the fire department who visited the spot and conducted an estimation as to the loss cost. So based on this complaint, criminal proceedings were initiated against the accused versus punishable under section so on. The investigating officer, after conducting a spot inspection, after recording the statement of the complainant and other eyewitnesses, filed a charge sheet for the offences punishable under 143, 435, 447, and 149. The trial court took cognizance of the said offences and issued process and secured the accused and who were released from bail. Stop. The accused pleaded not guilty to a charge framed by the trial court, claimed to be tried. Stop. Later, the petitioners have filed this petition contending that though the offence allegedly occurred on 25/2/2015, the complaint discloses that it was lodged before the jurisdiction police on 14/3/2015. It is stated that there is no explanation offered by the complainant for the delay in lodging the complaint. It is further contended that except a burnt coconut frond, FROND, the police did not recover any incriminating material. Therefore, the case of the prosecution was not believable. It is also contended that between the accused and the complainant, there was a litigation in OS number 170 of 1995 concerning the land bearing survey number 77 of same village, Teganahulli, and that the said suit was decreed for declaration of the title of the accused and for perpetual injunction. And the same was confirmed before this court in regular second appeal 2859 of 2007. Stop. The complainant is stated to have filed yet another suit in OS number 125 of 2015 for perpetual injunction in respect of the land bearing survey number 98 of Teganahulli, that the said suit is still pending. Said suit, which is pending consideration before the civil judge, Union Division, Mr. Rajpete. He submits that the complaint lodged by the respondent number 2 also concerns the land bearing survey number 98. And therefore, the criminal prosecution of the petitioners is therefore deliberate, and a false case is hoisted against the accused. Stop. Per contra, the learned counsel for the respondent number 2 supplies that in similar circumstances, this court in criminal petition 1494 of 2018 had held that mere disposal of the suit in OS number 170 of 1995. Mere decree granted in OS number 170 of 1995 not justify the claim of the accused that the complainant had lodged a false case. He therefore submits that in the present case too, the petitioner and the accused are the same, and the offense and the allegations made against the accused are largely the same, and therefore this court may not interfere with the criminal proceedings initiated against the accused. Next paragraph. The HCGP on the other hand submitted that the jurisdiction police after investigation has filed a charge sheet, and the trial court after applying its mind has taken cognizance of the said offences, and therefore this court may not exercise power under section 482 of CRPC to set it not the criminal prosecution. Stop. I consider submissions made by the learned counsel for the petitioner as well as the learned counsel for the respondent and the learned HCGP. I have also perused the charge sheet as well as other documents enclosed in the charge sheet. Next paragraph. It is not in dispute that the parties are litigating. It is not in dispute that the litigation launched by the accused in OS number 170/1995 concerning the land bearing survey number 77 of Teganahulli village is concluded in favor of the accused. Full stop. It is also not in dispute that the complainant has filed a suit for perpetual injunction in OS number 125 of 2015 concerning the land bearing survey number 98 of Teganahulli, and that the said suit is pending consideration before the trial court. Full stop. The complaint discloses that the accused attempted to enter the land in survey number 98 of Teganahulli 103 initially attempted to enter upon the land bearing survey number 98 of Teganahulli on 23 page. Is the page? What is the page? 10? Initially attempted to enter the land bearing survey number 98 on 23 to 2015. Thereafter, they renewed their attempts on 25 to 2015, in respect of which separate complaints were launched. To stop. It was alleged that the accused entered the land bearing survey number 103 belonging to his son and lit up a coconut tree. Full stop. Though the offence allegedly was committed on 25/2/2015, the complaint is stated to have been lodged before the jurisdictional police on 14/3/2015, and the FIR was also drawn on 14/3/2015. There is no explanation offered to the complaint regarding the delay in launching the complaint. Full stop. Even otherwise, the fact sheet discloses that there are civil proceedings pending between the parties, and the possibility of the accused being arraigned in a criminal prosecution cannot be ruled out. Full stop. In that way of the matter, the proceedings initiated against the accused / petitioners herein do not that way of the matter, the proceedings against the petitioners are not justified, and therefore they deserve to be quashed. Hence, this petition is allowed. All criminal proceedings initiated against the accused in crime number so on the file of CC number so on the file of so for the offences punishable on section 143, 435, 447, 149 of IPC are quashed. The petitioners are set free. Yes, next. Number 30, 31. The last time also did the same thing. Password. The Shivram. Yes. Here is a 72,000 for settlement of a matrimonial dispute. ಯಾರು ಕೊಡ್ಬೇಕು? Complaint has to pay to accused number 2 now. Complaint has to pay, no? Petition has to pay to the. Where's the 138 procedure? Where's the private company? Vote. Umesh. CS Umesh. Indian challenge ಮಾಡೋದು. Who is the Sandeep? The Sandeep Gowda is a lawyer. ಏನಂತ ಓದಿ. This is reference to this accused. Versus Sandeep Gowda. ರಾತ್ರಿ 8 ವೇಳೆಗೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಆಯ್ತು ಆಯ್ತು ಎಷ್ಟು ಯಾವ ಈ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ಸ್ ಅಂದ್ರೆ ನೀವು 2018 ಇಸ್ವಿಯಿಂದನೂ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಆಯ್ತು 77,000 ಯಾವ ಕಂಪ್ನಿ ಯಾವ ಫಸ್ಟ್ ಆಯ್ತು ಫಸ್ಟ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಯಾವ Learn counsel for the petitioners, learn counsel for the petitioners and the learn counsel for the respondent who submits that this criminal case arises out of a financial transaction between the petitioner in criminal petition 5017 of 2019 and the respondent number 2. They submit that the parties have amicably settled the dispute in terms of which the respondent number 2 has agreed to pay up about 72,000 towards full and final settlement of all claims of the petitioner in criminal petition 5017 of 2019. The learned counsel for the petitioner acknowledges that if a sum of 72,000 is paid, the petitioner would have no grievance, that all criminal prosecution of the respondent number 2 for an offence under section 138 of the Negotiation Act would also be put to an end. So, in view of the aforesaid submission, the counsel for the respondent number 2 is directed to secure the respondent number 2 to record a statement before this court to compound the offences. List on ಯಾವತ್ತು ಎಲ್ಲಿದ್ದಾರೆ ಲೇಡಿಶಿ ಏನ್ ಮಾಡೋದು ಯಾವಾಗ ಹೇಳಿ 77,000 3 ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ಸ್ ಒಂದು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಎಷ್ಟು ತಿಂಗಳು The counsel for the respondent number 2 submits that the said sum of 72,000 shall be paid in 3 installments spread over 3 months. Installment ಯಾವತ್ತು first installment ಯಾವಾಗ ಕೊಡ್ತೀರಿ? Installment 25th March 2023 for payment of the first installment and to report settlement to the parties. You please get all the cases 138 ಏನೇನಿದೆಲ್ಲ ತಗೊಂಡ್ಬನ್ನಿ. You also don't launch any further case against her. ವಕೀಲರು Vakil, you should not again file one more case against this lady. ನಿಮಗೆ ಗೊತ್ತಿಲ್ದಿರೋ ವಕೀಲ್, ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ದಿರೋ 100 ಜನ ವಕೀಲರಿದ್ದಾರೆ ಈ ಕೆಲಸ ಮಾಡೋರು. You might know, but do you know what he does in the evening?
Under the circumstances of this case, I can say, the blackmailing of the lawyer by
It's easy to say, you can't rule out anything.
same time. The party also.
Yes, yes, next. 25th years, actually. 24th, 24th. 24th. 33. Yeshuda. Huh? Learn concept for the respond number 269. Tomorrow we listen to the Rajgopal Naidu. What is the case the complaint is? Any other matrimonial case pending between the parties? What is the next case? Filed by whom? Cousin of the against whom? Against the husband. You admit. Imprimatur granted as a extent to the next state. Granted disposal of this petition. Yeah. In my mercy, Raghavendra. Huh? In my.
Lord, I appear for Lord of the petitioner. My Lord, a plain reading of the complaint will indicate, my Lord, that this is a pure civil dispute. May I trouble your lordship to kindly see the complaint, my Lord?
Yes. Yes, sir.
My Lord, the complaint is dated 4/10/2019.
Yes.
If your lordship will be kind enough to see criminal petition number 7882 of 2019, it is found at page 19. Please permit me to just read this, my Lord, and this is going to be my submission. I am the absolute owner of the property bearing number so and so, consisting of 15 residential apartments in it. I was approached by one company named Zenify in short and entered into a memorandum of understanding to be my agent for maintaining the property with certain terms and conditions, under which they said Zenify agreed to pay an assured sum of 1,74,800 per month as rent within 5th of day of next month. When this being the smooth agreed transaction, the said Zenify handed over the maintenance to another similar service company named Nestaway. And the said Nestaway agreed to pay the same amount with the same terms and conditions. The said Nestaway, from the date of taking the responsibility of maintenance, have never maintained the building. And there were many complaints from the tenants for non-maintenance, and I have to personally take care of the building at my own cost and expense, in spite of my heavy, busy work. Moreover, Nestaway is also not bothered to pay the assured sum and is due from the month of May 2017 till date, which adds up to 31 months. And the agreed monthly assured sum was 1,74,800, which totals to 54,18,800 for 31 months. Out of it, Nestaway have paid only 7,21,095, and the remaining amount of 46,97,705 is due from the said Nestaway. Now this Nestaway is not bothered to pay the said amount, nor maintaining the apartment, and also not paying any GST and TDS payable. Nestaway is used to me sum of rupees so and so. Hence, I request you to take severe action against said the Nestaway and his directors, whose details are given hereunder, for cheating me with a sum of rupees 46,975, and kindly instruct the said Nestaway and his directors to pay the amount due to me along with interest 18% per annum immediately, and also take necessary actions for cheating the government for non-payment of TDS and GST, since all my efforts went in vain in claiming the amount, hence this complaint.
Yes.
But clearly, a criminal proceedings ought to be initiated for the purpose of recovery. And then, my lord, the petitioners are two directors, no allegation against them. Absolutely no allegation.
So pay this monthly, whatever rent that you are supposed to pay.
No, my lord, that is not correct, because it is not a tenancy agreement. Kindly see that agreement, my lord, for a minute. It is not a tenancy agreement, my lord. It is an agreement for maintenance. If your lordship will kindly see the agreement itself, which has been produced by us. My lord, it has been produced along with a memo, my lord.
Then we'll ask him to take over the possession.
No, but he has taken over. They are already in possession. We are not in possession anyway.
Already taken.
Yes, yes. And now, my lord, in the police station, he has said that he will go for arbitration. He has given a letter, and my colleague, my lord, who is there before. My colleague, my lord, who is there before the court, is giving your lordship the statement that the complainant has made before the police, saying he will go for arbitration. Let him go for arbitration, my lord. We have, in fact, according to us, we have to recover money from him.
Sir, does the agreement provide for arbitration?
My lord, yes, yes. My lord, if you also will kindly see, my lord, the agreement which has been produced, my lord, along with the it is at page, is annexure C in the other petition, my lord. In the other petition filed by Amarendra Sahu, who is another director.
Yes,
And if you also will kindly see that agreement, my lord,
yes, sir.
it says this agreement is effective on and from 19th of March 2018, which is the date of on which Zenify achieves 100% occupancy of the scheduled property. That is when all the apartment units in scheduled property have been licensed by Zenify at least once. And that has not happened according to us. Therefore,
Yes.
we are not the tenants, my lord. I do not as if we have occupied the property and we are liable. We are only management company.
Yes.
And therefore, this is not an agreement where I am liable to pay. This whole thing operates when.
Correct. It is a written agreement.
Register member. Very register is the register company. Complaint to very same station.
But is that a cause of action for lodging criminal prosecution?
Investigation to the.
So that is a case for termination, the breach of trust, or breach of conditions of the contract. Sleeping will interest.
There is no agreement between the.
Yes.
Now entered into agreement between.
What has happened? What has happened to the possession? Let's go back to possession. You have to fight for recovery of the maintenance charge, license fee.
License fee and maintenance charge matter.
Admit. Mistake of all further proceedings. Pending disclosure of this criminal proceeding. In the
In
meanwhile,
fact, if your lordships are pleased, my lord, it can be disposed of, my lord. Let them start a civil proceeding and we can go on, my lord.
let them file the arbitration. Let us see.
Let them start an arbitration. That is their prerogative.
Let the sword be hanging on your head. Please, avagaru settlement ಮಾಡ್ತೀರಾ? Tomorrow, if you want to go out of the country.
Yeah, no, in fact, he has given a letter to the police.
If you want to go out of the country,
My lord,
charge sheet will come into, it will stop you from going out of the country.
I understand.
Therefore, then you will settle.
But kindly see the letter he has given to the. But your lordship may see the letter he has given to the police. He himself has given the letter to the police.
Yes. Please settle it, sir. These are all commercial transactions. People who do business should not be in the court.
Exactly. They should sit down and settle it.
Yes,
And in fact, he has given a letter saying that he wants to go for conciliation.
I think you will settle it right away.
But that I have to take instructions. I have no instructions.
When will you get instructions, sir?
My lord, kindly give me about 10 days time. I'll get instructions and get it.
The learned senior counsel for the petitioner submits that there are possibilities of a settlement. Hence, to enable them to work out the settlement, list on. When do you want it, sir?
After about 10 days, my lord.
List on 28th March.
Yes.
Devaraj. TV 14. It's not maintainable. We are reading it, it's not maintainable.
And some other laws, attempt has been qualified as an offense. So.
What is offense? Seven A and 8.
There's a proper feature towards money was.
ಯಾವ office?
Baseline measures.
Seizure was from whom? Who is the petitioner? You hold a license? Either weight scale, little weighbridge. How can you proceed? If they have a license, they could have been indulging in other things which are not permitted under the license. That could be a ground for cancellation of the license.
Whether they can be responsible.
Have you prosecuted the public servants?
Secure instructions of documents. Yes.
Then you short accommodation to Varabara Tawaltane.
And there are other matters that we are trying.
This case I remember of having heard.
Unfortunately for me, I'm not able to look at it. See, go back. First step, we are still having.
So therefore only one person cannot handle. Why don't you ask the Lokayuktha to have?
Also there.
No, but from ACB to Lokayuktha, you are the only one. You are the only one. So I think it's high time that we have more. Because it's.
They are not giving me IOs, that is the problem. I am not getting the details of that. So the transitional issue inside your
Counsel for the respondent number 169. Last chance respond. 20% marks. Sunil Kumar Patel.
My lord, I appear for petitioner in this case, my lords.
TP.
My lords, synonym,
Yes, Sunil Kumar Patel.
please, my lords. My lords, this petition is filed by accused number 2. The offences alleged are, my lord, 405, 406, 463, 464, 466,
What are the
467.
offences?
Cheating and forgery is alleged.
65, 466, 468,
471, 473, 474, 420, with 120.
What is the allegation?
My lord, this accused is a loan agent who has facilitated CW6 and CW6 and CW7 in procuring a site, wherein that was mortgaged with the Canfin Bank, that is respondent number 2, and later it came to the knowledge of this CW6 and 7 that the property which was sold in favor of them was already mortgaged with the other bank, and hence the alleged cheating and forgery has committed by the accused, my lords.
Yes.
Admittedly, this accused is neither the owner of the property and nor the beneficiary out of the loan which has availed by CW6.
What is the allegation? The complaint.
He was not named in the FIR, please, my lords. Was
3 to A5. So what is the allegation against accused number 2?
my lords, accused no-
To A2. A1 has sold the property. 2? Correct.
May I give the sequence? The client is able to claim in the 29. But the bank in a last day complete.
29.
29.
Yes, please.
The complaint is dated 13/11/2014.
29 is something else. Charge sheet of
Out of the.
in the second petition.
petition.
Date 29.
What?
The complaint against the following accused under section 405, 406, 406. Page number 1, Loretta Carroll. Well-known With reference to the above statement, we would like to bring your kind notice that Captain Notes Limited is a nuisance finance company registered by the place for the provided by the National Housing Bank for its various commercial transactions. And having registered office for interest. I submit the first and second account of the company. Financial institution. First accused is the applicant. Second accused is the public. Third accused is the guarantor to the loan project. The complainant of the having with the interest of the on 18 that loan was to be repaid within a period of 2 to 3 years. The loan carries the interest. First accused has created the market for development on which the above both the accused is the vendor of the above mentioned. I submit that the first and the second accused have accepted the conditions as was executed various market transactions in Europe. Being on the basis and process section the entire amount of business to be accused on the date of registration vendor, the accused number and accused to avoid the receipt. I submit that the accused has shown the property is going to farm at the time of discovery. The complainant submits that after taking the loan amount, the accused became very deviant and does not pay the the checks issued by the accused for getting out for one person, and now the account becomes very irregular.
What is the case against this accused number 1, 2, 3 and accused number 5? The person like one of the money ultimately has gone to accused number 4.
Charge sheet, in the charge sheet, the person is accused number 1. He is Rajkumar. This is the seller. They dropped to the purchaser. They included 3 of the bank officials, accused number 3, 4, and 5. The page 18 you will not look at it.
3, 4 and 5 are bank officials.
Bank officials. ನಮ್ಮಲ್ಲಿ ಏನೂ ಇಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಿರೋದು ನಾವು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿರೋ ಒರಿಜಿನಲ್ ಕಲರ್ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. And the first accused, the accused number 3, AGM, who collected the he loan ಕೊಟ್ಟಿರೋದು 2012 ಅಲ್ಲಿ 2 ವರ್ಷ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಕಟ್ಟಿದ್ದಾರೆ. Knowing your lordship will kindly see the statement of the original accused, page number 134. Now, Bangalore complaint we lodged the complaint against
who is accused number 2?
Accused number 2 happens to be a loan agent, my lord. He was not named in the FIR. He was implicated on the basis of statement of one Ramaraju, who is accused number 3 in the FIR, please, my lords.
What does he say against you?
My lord, page number 62 of my petition, my lord, I have annexed his statement, please, my lords. Ink page number 62, annexure G, please.
62.
62 to 64, please.
Yes, please.
Yes. ನಾನು ಮೇಲೆ ತಿಳಿಸಿರೋ ವಿಳಾಸದಲ್ಲಿ ಸೋನ್ಸೋ ರೊಂದಿಗೆ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ಬಿಡದಿ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಏರಿಯಾದಲ್ಲಿ ಟೊಯೋಟಾ ಕಿರ್ಲೋಸ್ಕರ್ ಕಂಪನಿಯಲ್ಲಿ ಪೇಂಟ್ ಶಾಪ್ ನಲ್ಲಿ ಟೀಮ್ ಲೀಡರ್ ಆಗಿ ಕೆಲಸ ಮಾಡಿ. ಇದಕ್ಕೂ ಮೊದಲು 2014 ಜೂನ್ 15 ನಂದಿನಿ ಲೇಔಟ್ ಕೊಮ್ಮಘಟ್ಟ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದೆ. ನಾನು ಕೆಲಸ ಮಾಡುವ ನಮ್ಮ ಕಂಪನಿಯಲ್ಲಿ ನಮ್ಮ ಸ್ನೇಹಿತರ ಬಳಿ ಸಾಲ ಮಾಡಿಕೊಂಡಿದ್ದ ಸಾಲದ ಹಣವನ್ನು ವಾಪಸ್ ಕೊಡಲು 2012 ಎರಡನೇ ಸಾಲಿನಲ್ಲಿ ನನ್ನ ಸ್ವಂತ ಮನೆಯ ಮೇಲೆ ಯಾವುದಾದರೂ ಬ್ಯಾಂಕ್ ಸಾಲವನ್ನು ತೆಗೆದುಕೊಳ್ಳಲು ಹುಡುಕುತ್ತಿದ್ದಾಗ ಜಸ್ಟೈಲ್ ಮುಖಾಂತರ ವಿಜಯರಾಜ್ A2 ಮೈಲಾರ್ಡ್ಸ್ ಎಂಬ ಏಜೆಂಟ್ ಅವರು ಪರಿಚಯವಾದರು. ಅವರಿಗೆ ನಾನು ಮಾರ್ಟ್ಗೇಜ್ ಲೋನ್ಗಾಗಿ ಪ್ರಯತ್ನಿಸಿದ್ದು ಸದರಿ ಲೋನ್ ಅನ್ನು ಕೊಡಿಸುವಂತೆ ಕೇಳಿದಾಗ ಅವರು ಯಾವುದಾದ್ರೂ ಬ್ಯಾಂಕ್ ನಲ್ಲಾದರೂ ನಿಮಗೆ ಲೋನ್ ಮಾಡಿಸಿಕೊಡುತ್ತೇನೆಂದು ಹೇಳಿ ನಮ್ಮ ಮನೆಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲಾತಿಗಳನ್ನು ತೋರಿಸುವಂತೆ ಕೇಳಿದರು. ಅದರಂತೆ ನಾನು ನಮ್ಮ ಮನೆಯ ಅಸಲು ದಾಖಲಾತಿಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಅವರಿಗೆ ತೋರಿಸಲಾಗಿ ಅವರು ನಮ್ಮ ಮನೆಯ ಅಸಲು ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನನಗೆ ಕನಿಂಗ್ಹ್ಯಾಮ್ ರಸ್ತೆಯ ಕ್ಯಾನ್ಫಿನ್ ಹೋಮ್ಸ್ ಲಿಮಿಟೆಡ್ ನಲ್ಲಿ ಲೋನ್ ಮಾಡಿಸುವುದಾಗಿ ಹೇಳಿದರು. ಅಲ್ಲದೆ ನಾನು ಲೋನ್ ಮಾಡಿಸಲು ಒಬ್ಬರು ಗ್ಯಾರಂಟರ್ ಬೇಕಾಗುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿದಾಗ ನಾನು ಹುಡುಕುತ್ತೇನೆಂದು ತಿಳಿಸಿದೆನು. ಅದಕ್ಕೆ ಅವರು ನನಗೆ ಪರಿಚಯ ಇರುವವರು ಒಬ್ಬರು ಇದ್ದಾರೆ, ಅವರು ಸಹ ನಿನ್ನಂತೆಯ ಬೆಂಗಳೂರು ಪೂರ್ವ ಕೃಷ್ಣರಾಜಪುರ ಹೋಬಳಿ ನಾರಾಯಣಪುರ ಗ್ರಾಮದಲ್ಲಿ ಖಾತಾ ನಂಬರ್ 764A ನಿವೇಶನ 57 ಅನ್ನು ಖರೀದಿಸಲು ಲೋನ್ಗಾಗಿ ಅಪ್ಲೈ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಅವರು ನೀನು ತೆಗೆದುಕೊಳ್ಳುವ ಲೋನ್ಗೆ ಗ್ಯಾರಂಟರ್ ಆಗಿ ಸಹಿ ಮಾಡುತ್ತಾರೆ. ಅದರಂತೆ ನೀನು ಅವರು ತೆಗೆದುಕೊಳ್ಳುವ ಲೋನ್ಗೆ ಗ್ಯಾರಂಟರ್ ಆಗಿ ಸಹಿ ಮಾಡು. ಇದು ಕೇವಲ ಮನೆಯ ವಿಚಾರವಷ್ಟೇ ಎಂದು ತಿಳಿಸಿದರು. ನನಗೆ ಆಗ ಜರೂರಿಯಾಗಿ ಲೋನ್ ಬೇಕಾಗಿದ್ದರಿಂದ ಆಯ್ತು ಎಂದು ಒಪ್ಪಿಕೊಂಡೆ. ಇದಾದ ನಂತರ ಒಂದು ತಿಂಗಳ ನಂತರ ದಿನಾಂಕ 18/2 ವಿಜಯರಾಜ್ ಅವರು ನಿಮಗೆ ಕರೆ ಮಾಡಿ ಲೋನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಪ್ರೂವ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ನಿಮ್ಮ ಸಹಿ ಬೇಕಾಗಿದೆ. ಅದಕ್ಕೂ ಮೊದಲು ನೀವು ಬೆಂಗಳೂರು ಪೂರ್ವ ಸೋ ಖಾತಾ ಮನೆ ಸಹಿತ ನಿವೇಶನ 57 ಅನ್ನು ಖರೀದಿಸಲು ಲೋನ್ಗಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಲೊರೆಟ್ಟಾ ಕೆರೋಲ್ ಮತ್ತು ರೆಡಾಲ್ಫ್ ಕೆರೋಲ್ CW6 and 7 ಅವರ ಸಾಲಕ್ಕೆ ನೀವು ಜಾಮೀನುದಾರರಾಗಿ ಸಹಿ ಮಾಡಿಕೊಳ್ಳಲು ಬ್ಯಾಂಕಿನ ಹತ್ತಿರ ಬನ್ನಿ ಎಂದು ತಿಳಿಸಿದ್ದು. ಅದರಂತೆ ನಾನು ಕ್ಯಾನ್ಫಿನ್ ಹೋಮ್ಸ್ ಬಳಿ ಬೆಳಿಗ್ಗೆ 10:30 ಹೋದೆ. ಅಲ್ಲಿ ವಿಜಯರಾಜ್, ಲೊರೆಟ್ಟಾ ಕೆರೋಲ್ ಮತ್ತು ರೊಡಾಲ್ಫ್ ಕೆರೋಲ್ ಅವರುಗಳ ಬ್ಯಾಂಕ್ ಬಳಿ ಇದ್ದರು. ವಿಜಯರಾಜ್ ಅವರು ನನಗೆ ಪರಿಚಯಿಸಿದ ನಂತರ ನಿನ್ನ ಸಾಲಕ್ಕೆ ಗ್ಯಾರಂಟರ್ ಆಗಿ ಸಹಿ ಮಾಡುತ್ತಾರೆ, ನೀನು ಇವರೊಂದಿಗೆ ಬ್ಯಾಂಕಿನ ಒಳಗೆ ಹೋಗಿ ಅವರ ಸಾಲಕ್ಕೆ ಗ್ಯಾರಂಟರ್ ಆಗಿ ಸಹಿ ಮಾಡು ಎಂದು ತಿಳಿಸಿದ ಮೇರೆಗೆ ನಾನು 18/2/2012 ಬೆಂಗಳೂರು ನಗರ ಕನಿಂಗ್ಹ್ಯಾಮ್ ರಸ್ತೆಯಲ್ಲಿರುವ ಕ್ಯಾನ್ಫಿನ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಒಳಗೆ ಲೊರೆಟ್ಟಾ ಕೆರೋಲ್ ಅವರ ಪತಿ ರೊಡಾಲ್ಫ್ ಕೆರೋಲ್ ಅವರೊಂದಿಗೆ ಹೋದೆ. ಅವರು ನನ್ನನ್ನು ಬ್ಯಾಂಕಿನ ಅಧಿಕಾರಿ ಬಳಿಗೆ ಕರೆದುಕೊಂಡು ಹೋದರು. ಬ್ಯಾಂಕಿನ ಅಧಿಕಾರಿಯವರು ಲೊರೆಟ್ಟಾ ಕೆರೋಲ್ ಅವರ ಸಾಲದ ಅರ್ಜಿಗೆ ಅವಶ್ಯಕತೆ ಇದ್ದ ಗ್ಯಾರಂಟರ್ ದಾಖಲೆಯನ್ನು ನನ್ನಿಂದ ಸಹಿ ಪಡೆದುಕೊಂಡೆ. ಆಗ ನಾನು ಸಾಲಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಸಾಲಕ್ಕೆ ನೀವು ಗ್ಯಾರಂಟರ್ ಆಗಿ ಸಹಿ ಮಾಡಿರಿ ಎಂದು ಕೇಳಿಕೊಂಡೆ. ಅದಕ್ಕೆ ಅವರು ಒಪ್ಪಿಕೊಂಡರು. ಲೊರೆಟ್ಟಾ ಕೆರೋಲ್ ಅವರು ಬೆಂಗಳೂರು ಸೋನ್ಸೋ ನಿವೇಶನ ದಾಖಲೆ ಪತ್ರಗಳನ್ನು ನಮಗೆ ಬ್ಯಾಂಕಿನಲ್ಲಿ ತೋರಿಸಿದ್ದು, ಲೋನ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡ ಸಮಯದಲ್ಲಿ ಮುನಿಯಪ್ಪ ರೋಡ್ ಮಾರುತಿ ಸೇವನ ಬಾನಸವಾಡಿ ಬೆಂಗಳೂರಲ್ಲಿ ವಾಸವಿರುವುದಾಗಿ ತಿಳಿಸಿದರು. ಆದರೆ ಲೊರೆಟ್ಟಾ ಕೆರೋಲ್ ಅವರು ಶ್ರೀಮತಿ ರಾಜಕುಮಾರಿ, ದಟ್ ಈಸ್ A1 ನನಗೆ ಸೇರಿದ ಸೋನ್ಸೋ ಗ್ರಾಮದಲ್ಲಿರುವ ಖಾತಾ 764ಗೆ ಮನೆ ಸಹಿತ ನಿವೇಶನಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕಲರ್ ಜೆರಾಕ್ಸ್ ದಾಖಲಾತಿಗಳನ್ನು ಕ್ಯಾನ್ಫಿನ್ ಹೋಮ್ಸ್ಗೆ ನೀಡಿ ಸಾಲ ತೆಗೆದುಕೊಂಡು ಮೋಸ ಮಾಡಿರುವ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ. ಅಲ್ಲದೆ ಬೆಂಗಳೂರು ಪೂರ್ವ ಸೋನ್ಸೋ ನಿವೇಶನ 57ಗೆ ಸಂಬಂಧಿಸಿದ ಅಸಲು ದಾಖಲಾತಿಗಳನ್ನು ರಾಜಕುಮಾರಿ ಅವರು ಮೊದಲು ದಿ ಭಾವಕ್ಷತ್ರಿಯ ಕೋಆಪರೇಟಿವ್ ಬ್ಯಾಂಕ್ ಲಿಮಿಟೆಡ್ಗೆ ಅಡಮಾನ ಮಾಡಿ ಆಗಲೇ ಸಾಲ ತೆಗೆದುಕೊಂಡ ವಿಚಾರ ಮತ್ತು ಅದೇ
A3, A4 and A5 ಅವ್ರ ಮೇಲೆ ಏನಿದೆ?
ಅವ್ರ ಮೇಲೆ ಏನೂ ಇಲ್ಲ.
What is the what you call evidence collected by the prosecution?
Except the statement of originally against whom we are not talking. There is nothing else.
What is the evidence collected as so far as the bank officials are concerned? Is for who has said that? Has anybody said that?
The evidence is the they are examined the law. Yes. And they have sent it to valuation. The real original will be collected at the time of registration. You ಒಬ್ಬರು ಬ್ಯಾಂಕ್ ಇಂದ ಕಳಿಸಿದ್ದಾರೆ. He has gone to hand over the DD. He has handed over the DD. ಅವನು ತಂದು ಇಟ್ಟಿದ್ದಾರೆ. ಅದು ಬಿಟ್ಟ ಮೇಲೆ ಅದು ಬರುವ 2 years, loan 2 years ಕಟ್ಕೊಂಡು 2 years ಆದ್ಮೇಲೆ loan ಕಟ್ಟಿಲ್ಲ. They came to know that this property is original forgery.
Why was the original document?
Even back then,
That's Xerox saying.
he couldn't, the A5 couldn't make it because A3 and A4, they have never seen the original. Because they have, A3 is the scientific authority, he will not verify the original. He will go by the recommendation of this.
Correct.
Only
A5, what about A5?
Only A5. But A5, he says, I believe it is forgery.
Who is he? He's also bank.
He got one of the, but got the branch.
So. So. Yeah. Ah. Yogi Vaishya to all one. Then argue on Madi, what is this? An offense? Very entry model. No wonder you seek for a time.
I have already been. We have.
Do you want it?
Today,
Thursday and Friday is reserved for other matters. The request of land council for the petition as a last chance list on Monday. For the extent to the next. ಎಲ್ಲ ಅರ್ಧ ಟೈಮ್ ತಗೊಂಡ್ರೆ ಏನು council for the petition, see number 51. Council for the petition seeks time. ಏನು counter, you are for the petitioner, what counter? Counter ಹಾಕ್ಬೇಕಾ? Huh? What are you're supposed to file a counter to the counter or what? Huh? Okay, counter. You 482, what is this? Whatever it is, 482 on counter, service joinder to service joinder. Also for the petition seeks time as the last chance list on date for. Then 43. Request of law council for the petition list on. Number 10. Number 10 entry material. What say the original document? What stage should the bank officials secure the original documents?
Because here to say these are all the original documents. Original documents are generally identification may not last to the and I've seen all the original documents. There are many.
There's a report, title scrutiny report. Has that been seized by the?
Not part of the test.
If it's not part of the charge sheet, then
But
no.
no matter that, last time. So officers and others following normal procedure, that's what. And then they return that the rent was starting found that the house offer is there. And then they sent for valuation, here someone will say that he is the owner of the property and property value so much. That is sanction by last law. Because then my heart there is nothing. And that is why was the period installments. 1 year, 2 years. And therefore become NPA. How become NPA is start to go. The register then the here that the property they are not registered, not here. So the bank that the new certificate also.
Please tell me, proceed against this accused. Accused number 2 is the broker. Correct? What is the old act against him?
No, broker is these people are different. All is how we can they agent will be there. That agent will bring the customer.
Now, how will you know, how will you know that this document is, what you call, this property is already mortgaged? How will you know?
Not that, what happened.
Now the charge sheet is filed. Now the charge sheet is filed. Please point out from the charge sheet, what is the old act committed by accused number 2? Is there anything to show that he knew that these purchases did not have title? Broker yet, did he know? See, if he knowingly commits, then it's a crime. Without any knowledge, based on the information given by the owner, if he has brought about some transaction between the parties, he's only a broker. How is he involved in the crime? The only person whom I can see is accused number 1. Only accused number 1. Who is the seller? Only he knows. And bank officials, they process the paper at the time of registration when they hand over the check. He is supposed to collect the original documents. Original documents collect Madilla.
This is not the action.
Election ಮಾಡಿದ್ದಾರೆ. It's just.
Who is that person? He is accused number?
5.
He is accused number 5. What is there to show that accused number 5 has done it wantonly?
Because my heart is officers and not my son. I know because they have been working. Cannot be one person.
So how do you expect the bank officials, if it's a 1% case, how do you expect the bank officials to know all these things? It is only the accused number 1 who has to be prosecuted.
Because it's all the procedure they have followed because now.
So you're supporting the accused 3, 4, and 5.
Bank of assessment, they are not having, because my complaint is not mentioned.
Yes.
Now complaint may not, nothing is mentioned.
Yes. Like 120B, what is the material for 120B? Where is the meeting of minds? Meeting of minds, ಏನಾದ್ರು ಬೇಕಲ್ರಿ ಇಂಥ ಕಡೆ ಜಾಗ ಸೇರಿದ್ರು ಇವ್ನು ಹಿಂಗ್ ಮಾಡೋಣ ಅವ್ನು ಹಂಗ್ ಮಾಡೋಣ ಇಷ್ಟು ಏನಾದ್ರು ಇದೆಯಾ ಅಲ್ಲಿ? Is there a confession statement anywhere? ಇದೆಯಾ? There is not even a confession statement. Who are the charge sheeted witnesses? Who are the charge sheet witnesses?
Page 18.
Page 18.
18.
Minimum is enough. Page 18. Yeah. Bhaskar mechanic. Tanfin Homes. Govind Swami. Nirmala. Sundar. Chief Manager. Ajay. Mure Janana.
Next, page 22 continues.
Prakash. Pavasara Kshatriya. Protector Carol.
They are the procedures. Inside, sir.
Ramaraj. He is also cited as a witness.
Purchasers are guarantors and witnesses.
Then you also cite them as witness, Mr. HCGP. Let all these people be cited as witness. Anyway, 319 is always there. The petitioners were accused number 2. The petitioner in a criminal petition 6768 of 2020 is the accused number 2. Well, the petitioner in criminal petition 6252 of 2018 are the accused number 3 to 5. In CC number so and so on pending trial before so and so for the offences punishable under section 465, 466, 468, 471, 473, 474, 420, regular section 120B of IPC. The petitioners have all challenged the order dated petitioners have all challenged the cognizance of the offense taken by the trial court and trial court full stop and issuing warrant for the appearance of the accused. Next, the case of the prosecution was that the complainant lodged a complaint. Case number? Second petition. Right. First petition lodged a complaint. The case of the prosecution was that a complaint was lodged on 13/11/2014, alleging that CW 5 and 6 CW 6 and 7 at CW 6 and 7 had applied for grant of his housing loan for purchase of a property bearing site number 57, Kata number 764/A, situated B. Narayanpura village, Krishnarajapuram, Hubli, Bendu East Taluk. Full stop. The CW7 was the co-applicant. Full stop. Ramaraj is CW. CW8 was the guarantor. Full stop. The complaint alleged that after the application for housing loan was processed and sanctioned, housing loan of rupees 28 lakhs was sanctioned on 18/2/2012. Full stop. the CW 6 and 7 were expected to repay the loan in 240 equated monthly installments. Full stop. CW 6 had executed an equitable mortgage towards repayment of the housing loan. Full stop. The said property was purchased from the accused number 1. Full stop. It is claimed, it was alleged that CW 6 and 7 had also executed various documents on 18/2/2012. Full stop. Based on the documents aforesaid, the housing loan of rupees 28 lakhs that was sanctioned, was released to the accused number 1 on the date of registration of a deed of absolute sale by accused number 1 in favor of CW 6. Full stop. The complaint claimed that when the property was inspected, the accused number 1 had furnished all the original documents. Full stop. It was claimed that the CW 6, who initially paid some installments, failed to pay the remaining installments, and the checks drawn by CW 6 towards payment of the installments were dishonored. Consequently, the complainant treated their account of CW 6 as a non-performing asset and issued a demand notice under the provisions of Section 13 of the SurfaceZ Act 2002. Full stop. The officials of the complainant visited the property during August 2014 for inspection and found to their dismay that the property was already mortgaged to another financial institution. Full stop. It was only then that they came to know that the accused number 1 had handed over, accused number 1 had availed a loan of rupees 5.74 lakhs from Bhavasara Kshatriya Cooperative Bank Limited, Malleshwaram on 10/3/2010 and had executed a mortgage deed in favor of the said bank, the said cooperative bank. Full stop. It was also claimed that at the time of execution and registration of the deed of absolute sale in favor of CW 6, what was handed over was a colored Xerox, colored photocopy of this original sale deed. To stop. It was therefore alleged that the accused number 1, in an attempt to cheat the complainant, had compelled it to advance a loan on non-existing property. Advanced a loan on a property which is already mortgaged in favor of another financial institution. Full stop. The investigating officer registered a crime number. Mr. 331/2014 and took up investigation. After concluding the investigation, the charge sheet was filed for the offences punishable under Section 465, 466, 68, 71, 73, 74, 420 reduced Section 120B of IPC. To stop. The accused number 1 was the erstwhile owner of the property who had earlier mortgaged it to a cooperative bank and later sold it to CW6 and 7. While accused number 2 was a broker who brought about the loan transaction, who procured CW 8. He procured CW8 to stand guarantee for the loan raised by CW6 and 7. While accused number 3, 4, and 5 were the officials of the bank who had all processed the loan, sanctioned it, released it, and who was responsible for collecting the original document of title. Stop. The trial court, after considering the material placed along with the charge sheet, took cognizance for the aforesaid offences and issued a warrant to secure the presence of the accused. Being agreed by the cognizance taken by the trial court, the accused number 2, 3 to 5 are before this court in these petitions. Next paragraph. The learned counsel for the accused number 2 submitted that a thorough reading of the complaint lodged by the complainant does not disclose the involvement of accused number 2. He submits that the accused number 2 was roped into the case based on the statement of CW8. CW8. Full stop. He submitted that there was no involvement of accused number 2 in the commission of the alleged offence. And accused number 2 was not the beneficiary of any amount from the bank, any portion of the loan sanctioned by the bank. Stop. He therefore submits that prosecuting the accused number 2 would be a futile exercise. Full stop. The learned counsel for the accused number 3 to 5 submitted that the accused number 3 to 4 were officials of the bank who were responsible for processing the loan application submitted by CW6 and CW7, and that they had no role to play in the accused number 1 handing over a photocopy, colored photocopy of the sale deed at the time of execution registration of the sale deed in favor of CW6 and CW7. He therefore submits that he further submits that the prosecution, the investigating officer had not recovered any material to establish the link between the accused number 3 and 4 with the accused number 1. Full stop. Therefore, there is no material to proceed against the accused number 3 and 4. Full stop. Insofar accused number 5 is concerned, the learned counsel submitted that the accused number 5 was also an official of the bank who was supposed to receive the original sale deed at the time of execution and registration of a sale deed by accused number 1 in favor of accused number, CW6 and 7, and that he inadvertently and that he inadvertently collected the colored photocopy of the sale deed in favor of accused number 1 executed by his vendor. He submitted that this was a mistake. This was a genuine mistake, as accused number 5 could not identify the original not identify the colored photocopy of the original sale deed in favor of the accused number 1. We therefore submitted, full stop. We further submitted that there was no material collected by the prosecution to prove the guilt of the accused number 5, to prove the involvement of accused number 5 in the offense. Full stop. Next paragraph. The HCGP on the other hand submitted that the investigating officer, after conducting an investigation, has found that all the accused have in tandem committed the offense. Full stop. He submitted that the investigating officer has also found that all the accused had conspired to defraud the bank and therefore had invoked section 120B of IPC. He submits that the assertions made by the petitioners, so the accused number 3 to 5, are all a matter of trial, and therefore this court may not exercise jurisdiction under section 482 of CRPC. The Grand Counsel for the respondent number 2 on the other hand submitted that accused submitted that it was unaware that it was unaware about the complicity of accused number 3 to 5 who were its officials. The Grand Counsel submitted that the accused number 3 to 5 were honest officials of the bank, and therefore it also did not doubt the complicity of accused number 3 to 5, and there is no material to establish the complicity of accused number 3 to 5 in the offense. Full stop. And so far as accused number 2 is concerned, the Grand Counsel submitted that the complaint was unaware about the involvement of accused number 2. Full stop. I have considered the submissions made by the Grand Counsel for the accused number 2 to 5 as well as the Grand Counsel for the complainant and the learned HCGP. Next paragraph. The applicants, the CW6 and CW7, were the applicants who had sought for grant of a housing loan based on the security of the property that was agreed to be sold by accused number 1 in favor of CW6 and CW7. Full stop. The loan applications were processed by accused number 3 and 4. 3 and 4. Which was ultimately sanctioned. Full stop. Therefore, the role of accused number 3 and 4 came to an end soon after the sanction of the loan. Full stop. This sanction was apparently based on the title scrutiny report submitted by the concerned professional engaged by the bank. Full stop. Insofar as accused number 2 is concerned, he had secured CW8 to sign as to stand guarantee for CW6 and CW7 for the loan, and CW6 and CW7 in turn stood guarantee for the loan raised by CW8 from the bank. Full stop. Therefore, the role of accused number 2 in defrauding the bank is also not apparent. Full stop. Insofar as accused number 5 is concerned, he was the one who was supposed to receive the original documents of title of the property at the time of registration and execution of a deed of absolute sale. Full stop. The accused number 5 failed to exercise due care and caution while receiving the original documents of title from the accused number 1. Full stop. These facts do not establish the complicity of these accused in the offense under offense punishable under section 465, 466, 468, 471, 473, 474, 420, repeal section 120B. Full stop. There is no meeting of minds of the accused number 2 to 5 to establish the offences, the conspiracy and the consequent commission of crime punishable under the aforesaid provisions. Full stop. In that way of the matter, comma, the proceeding against these accused would be an empty formality, and therefore it is appropriate that these accused are cited as prosecution witnesses rather than proceeding against them. That way of the matter, comma, this petition under section 482 of CRPC is allowed, and the criminal prosecution of the accused 2 to 5 in CC number so and so on pending trial before so and so is set at naught, and the accused number 2 to 5 are set free. It is open for the prosecution to cite accused number 2 to 5 as witnesses of the prosecution. The right of the prosecution will stop. The powers of the trial court under section 319 of CRPC is kept open. 319 and section 173(8) is kept open. Complaint.
Actual correction. On the state registered on the.
Corrected, I got it. Yes. No. Yeah, I will. The problem. Yes. Learn counsel, learn experience each time. That's it, idea. So that this will not survive. This will not survive. Think about it. Good. And learn counsel for the petitioner. Put it. Fairly submits that. What was challenged? So what is challenged here in this case? So this should not survive. Good. Non-counsel for the petitioner fairly submits that the petitioner had earlier challenged criminal proceedings before this court in criminal proceedings initiated against him before this court in criminal petition 5865 of 2015. And criminal petition 2336 of 2016, which were dismissed. And a special leave petition filed before the Supreme Court in special leave SLP bracket criminal number 8551 of -8552 of 2019. It was reported that the charge sheet was already filed. Stop. He submits that the Honorable Apex Court, after considering the above fact, had permitted the petitioner to approach the trial court to argue before charge. So he submits that in view of the finding recorded by the Apex Court, this petition filed challenging the charge sheet does not survive for consideration, and therefore the petitioner may be reserved liberty to argue before charge before the trial court. In view of the aforesaid submission, this petition is dismissed. It is open for the petitioner to submit his arguments before framing the charge. All contentions are left open. The current Joseph Rosa Param. Looks like it's a cakewalk for you. Looks like it's a cakewalk for you. Mr. Thiruvantam looks very grim. You look very happy.
We finished last night outside.
Yeah.
The dispute is taking place between siblings. Siblings are aged 76 years, 81 years, and 71 years. What we have sought for is quashing of an FIR for offences punishable under 193, 420, 463, 465, 467, and 468 melons. Melons, the list of dates which is there along with the petition copy, there's a delay of about 12 years in instituting the.
Is there any civil proceedings pending?
Yes, my lord. In fact, this arises out of certain documents produced for probate. The probate proceedings was in Calcutta, my lords. In the probate proceedings, the present petitioner was the executor, my lords.
Yes.
Who was the executor, he filed sought for probate, my lords, of his father's will. In those proceedings, my lords, consenting affidavits of the brothers and the mother was filed. The probate was ordered, my lords. This was in 2009.
Yes.
Now, after about 12 years, in view of what transpired in between the siblings, comes this complaint which is sought to be given to the police station here in Bangalore. The allegation is the consenting affidavits were not there, it is fabricated documents. This was the allegation. Now, the police would refuse to register the FIR on the ground that it is purely civil in nature. They would prefer a PCR. In the PCR, there is a reference under 156.3. And that is how the FIR now comes to be registered. Now, in the sequence of events, list of dates, you can also see in the criminal petition itself, the very first page, this is about 5-6 dates there. Criminal petition, page 1, list of dates and synopsis will also get that. Now, 9/9/2005 is the date of will, the last will of the father of the present petitioner and respondents to agree. 23/2/2007, father would pass away, my lords. 15/9/2009, will of the father is probated by the High Court at Calcutta, letters patent. Original jurisdiction, my lords, in PLA number 171 of 2009, upon considering of supporting documents, including consent affidavits of the complainant, their mother and sister. Then, my lords, in 2021, the problem arises between the siblings, my lords. CP number 43, my lords, it should be of 2021. I'm sorry, it's shown as 2009. It should be 2021. Filed by the petitioner. Inter the respondent number 3 before NCLT for acts of oppression and misconduct. Well, between September to November, negotiations took place between the parties. Their various email correspondence. They would agree to pay some between 1.75 to 2 crores to the petitioner. Then, my lords, on 17/12/2021. Respondents 2 and 3 approached the Chandra Layout police station seeking action against the petitioner, stating that the aforesaid consenting affidavits of 2009 were forged. Now, very relevant to be 2009 was a probate. It was never challenged till this complaint comes to be filed. Then, my lords, the honorable.
Whether the court has taken into account the affidavits.
For the purpose of probate, it is necessary, because no objection.
No. As a court taken into consideration, the affidavits filed by these people at the time of granting probate.
If they are observed, so far as the remaining LRs are concerned, they have given their consent.
Where is the order?
Order of.
Yeah, you have a copy?
Yes.
There's something at page annexure F, page 58.
Yes,
Page 58.
Page 60, my lords, the typed copy. Probate, the executor. This must be only the contents or the final order, like, my lords, so probate is given.
There is a petition for probate. Page 1, page 52.
I will call it up. Yes. Page 52.
This Mr. Thiruvangam. Yeah. Yes.
Page 52, my lords.
Yes.
As far as the list of things, significant error. None of the dispute is on the citizens. The petitioner before my lords is a resident of that. And the complainants are residents of that. In the father accounts, without the knowledge of the petitioner's complaints, probate proceedings initiated. Signatures by affidavits of my parents, both signatures. The probate we are not aware of. Now, can we see the interim order? The interim order is being passed by misleading this honorable court as if both the complainants are party to a complete petition. On the contrary, there is a dispute between the third respondent hearing and the petitioner, the eldest and the youngest.
What is this company? What is the case before the NCLT?
Petitioner is a shareholder in a company. In which the third respondent is having a majority of shares, 92%, 92.5%. The is my initiative copy of this is not out till November 20. November. In the meanwhile, the first respondent, who is the eldest brother, did not want brothers to fight, initiates a dialogue without their knowledge of what. Initiate dialogue and persuade the youngest brother to pay a certain sum of money to the first petitioner. Without knowing the fact, the contents. Meanwhile, in August and September 2019, copy of the complete petition is served. And for the first time, it is discovered probate proceeding is a probate proceeding. So taken by surprise. They make an application for certified copy and kindly see the extent of forgery, palpable forgery. Kindly come to my lords, their own petition. I think my lords to the signature of the first respondent.
What are the subject matter of the probate proceedings?
Probate proceedings are property, renewable property, shares in company, business enterprises. I mean, it goes on. We are not even having a relationship between all the brothers subject till this case is come to this fight. Everyone thought that each one is running the business on behalf of the larger firm. We don't want to interfere. The first respondent is the eldest brother. Sure. The second respondent.
Have you found any case for recalling this probate?
Yes, that is pending. Moment you pay survey and come to page 33 maps.
Well, this case was pending. Let us.
No, there are two issues. One is under 193 is up to the court in the Calcutta High Court to take. Forgery has happened within the jurisdiction. The forgery has happened perfectly in Bangalore, taking a stamp paper on
Now that you challenge the probate. It's not for cancellation of the probate.
Probate cancellation of probate is totally different.
All right.
I just like to point out how the signatures will kindly come to page 33. The first complainant signature. In the verification my lord will see. His signature is something very unique, dot a number of lines. Second complainant signature is below. That is, first one is Ashok Kapoor, second one is Kriti Kapoor. Now kindly come to page 137. Sorry, page 45. Page 45. This is the forged document that is being used in the calculator. First complainant, Ashok Kapoor's signature, compare it with page 33, my lord. It's totally different.
Ashok Kapoor.
Yeah, this Ashok Kapoor is a series of lines. This is written as Ashok Kapoor. Ashok Kumar. Now, the second complainant, Kriti Kapoor's signature, page 33 is from here. And at page 52, this is the
Please to show any document that in the year 2009,
yes,
you are signing the same way as you signed in the year 2021.
I'll produce. In fact, along with an application that has been filed, forensic report also being used because of the IA.
Is there any document? Where is the affidavit? Where is the affidavit? Where is the affidavit?
Which affidavit, fellow? This is the affidavit that they filed in this calculator.
Page number 47.
Page 45
Yes.
and 52. All are admitted signatures of the relevant date. Everything has been given to the investigating officers. My signatures as on the date with the specific signatures my banks have produced to the investigating officers. This is it was in the investigation till the interim order comes into play. Now, kindly see what is important, my lord, is the interim order says, as if there is a company petition is between filed. As the first, the complainant have nothing to do with the company.
Yeah.
On the contrary, in their own petition, kindly see, my lord, they have filed email communications. Kindly come to page 67. This is the correspondence between the complainant, the petitioner, and the third respondent, that is Vinod Kapoor and Kriti Kapoor. It says, if pursuant to a discussion with our elder brother A.K. Kapoor, that is the first complainant. First complainant did not want the brothers to fight, took the initiative of trying to resolve the dispute. At this stage, he discusses giving his own signature as being closed. I don't gain anything out of this company dispute. As a first petition, as a first complainant, Ashok Kapoor does not gain anything out of the company dispute. He thought, I have nothing to do with this as the company petition. That being the case, here is a person.
Please show some document to say that in the year.
I find all the documents. In fact, forensic reports have been filed.
No, I don't want that. I need to see the authentic document in the year 2009, which contains your.
Give me a second. No, this is the bank. We are producing the Calcutta, or we produce it.
The senior counsel representing the respondents. So that you place on record an official document, an authentic document to show that the signatures of the complainants were not as found in the affidavits filed in PLA number 171 of 2009 before the High Court of Calcutta. What is the stage of the proceeding?
Madam, the application being heard.
Not before this court. Because investigating officer.
Investigating is being done.
Only crime is registered.
FIR which is state. One aspect that is point out there is statutory bar for this complaint. 195 1B1 because their allegation is section 193. If 193 is there, my lord, then it is for the court to give a complaint. 340 will come into play. Here, according to them, 193
Yes.
it is in relation to the proceedings in the court.
Yes.
So their own
You
case, my
consider
lord, is
the
standard
Injuries, kind of.
not a territorial jurisdiction and pointing out
No, no,
statutory bar in 193.
No,
No,
not necessarily.
this statutory bar, you know, police and university.
Saying in Kannada, ಮನೆ ಬೆಂಕಿ ಎತ್ಕೊಂಡು ಹೊಡಿತಿದ್ರೆ ಯಾರೋ ಬೀಡಿ ಹಚ್ಕೊತಾ ಇದ್ದಾರೆ. They are fighting, why you want this? All right, it is between siblings. Let us.
The property state in what matters.
Not you. No. Let us see. See if it was no. If the charge sheet was filed, the approach of the court would have been different. So therefore, let us see. Yes. Now they have filed an application for what you call setting aside the probate. The standard of proof in those proceedings is much lower than in a criminal prosecution. So let us see what happens to the application for setting aside the probate. If tomorrow if the court says that the probate is correct, then what happens? Then everything falls to the ground. ಸಿಕ್ಕಾಪಟ್ಟೆ ಕೆಲಸ ಅದನ್ನ ಮಾಡಿ ಯಾಕೆ
I'm not here. Case where signatures doesn't match.
it's all. See, I have changed my signature at least 3 or 4 times.
My duties to place all those.
Right. I have changed my signature at least thrice in my lifetime.
Signatures from them to now.
So therefore,
By the way, they say, dotted lines, and it cannot become Ashok Kumar Kapoor, which he has never done. Ritik Kapoor has also been, it's very descriptive, not a detailed. So, to that extent, and here is another who knows very well, takes advantage. As a matter of fact,
I don't know how old were they in the year 2009.
but I think 20 years less.
So 20 years and you can imagine.
So,
20 years they'll be fantasizing. Therefore,
now till 2019, the relationship was so that there is a petitioner now accused. So come and stay with me. And then there are so many other litigations, daughter phase, all this is done. And but quietly, someone tries to knock off the entire set of problems.
work out some settlement. Put an end to this litigation.
Like, we are close to that. 1.5 to 2, they agreed to give.
But
That is
not
something.
Right, that was regarding the NCLT case. That was regarding the case before the NCLT.
It's a case for us. Then they would say, we'll settle it for 1.75 to 2. Is it
Before the discovery of the.
then now they say after the complaint is valid, it was one complaint gets request statutory violence. I will give you point it out. See how much it goes into this. If you have this.
This term. Shanavas. ಮಾಡಿದ್ರಾ petitioner is present. Is it 6,000 rupees per month or what? Per month. Where is the sum? Where are the two sons? Mister, call your sons, call your client sons. ಮಕ್ಕಳು ಬಂದಿಲ್ವನ್ರಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಮಕ್ಕಳು? Bring them. Where's the other one? He is the oldest or he is the eldest?
He's the eldest.
Where's the younger one?
Don't know necessarily. He's the one who is taking care of this.
The younger one is taking care of the respondent. ಯಾರ ಜೊತೆ ಇದ್ದೀರಮ್ಮ ನೀವು? ನೀವು ಚಿಕ್ಕ ಮಗನ ಜೊತೆ ಇದ್ದೀರಾ? ಏನಿಲ್ಲ ಅದು ಆಮೇಲೆ ನೀವು ಚಿಕ್ಕ ಮಗನ ಜೊತೆ ಇದ್ದೀರಾ? ಏನಪ್ಪ ನಿಮ್ಮ ಅಪ್ಪ ನಿಮ್ ಜೊತೆ ನಿಮ್ಮ ಅಮ್ಮ ಎಲ್ಲಿರ್ಬೇಕು? ನಿಮ್ಮ ಅಪ್ಪನ ಹತ್ರ ಜಮೀನಲ್ಲಿ ಯಾಕೆ ಬರ್ಸ್ಕೊಂಡಿದ್ಯಾ? ಅದಕ್ಕೆ ನೀವು ಅಪ್ಪನ ಹತ್ರ ಜಮೀನು ಬರ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟ? ಇವಾಗ ಈ ಅಮ್ಮ ಹಿರಿಯ ಹೇಳ್ತೀನಿ ಚಿಕ್ಕ ಹೇಳ್ತೀನಿ ದೊಡ್ಡ ಹೇಳ್ತೀನಿ ಅಮ್ಮ.
ಇದೆಲ್ಲ ಸೌಕರ್ಯ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ
₹6,000 ಕೊಡ್ಬೇಕಾ ಅಮ್ಮಂಗೆ? ತಿಂಗಳಿಗೆ ₹6,000. ಈಗ ಅಮ್ಮನ್ ಇನ್ನೊಬ್ಬ ಮಗ ಅಂದ್ರೆ ಇವ್ರು
He's already working in.
one more son from the first wife or the second wife?
First wife died.
First wife died. ಸ್ವಂತ ತಾಯಲ್ಲಪ್ಪ ಅಮ್ಮ ಮತ್ತೆ ಅದಕ್ಕೆ ಜಮೀನ್ ಯಾವ ಸಂಪಾದನೆ ಮಾಡ್ಕೊಂಡು ಆಯ್ತು ಬಿಡಿ. ತಿಂಗಳಿಗೆ ₹6,000 ಕೊಟ್ಬಿಡಿ ಅಮ್ಮಂಗ್ ಹೋಗ್ಲಿ. ಆಯ್ತು. 84 ವರ್ಷ ಅಲ್ಲ ನಿಮ್ಗೆ ಕಾನೂನು. 84 ವರ್ಷ ತುಂಬಾ ಬದಲಾವಣೆ ಆಗ್ಬಿಟ್ಟಿದೆ. ಏನ್ ಮಾಡೋದು? ಕಾನೂನು ಬದಲಾವಣೆ ಆಗ್ಬಿಟ್ಟಿದೆ. ಹೆಚ್ಚಿಗೆ ಮಾತಾಡಕ್ಕಲ್ಲ. ಮುಂಚೆ ಇದ್ದಿದ್ದ ಕಾನೂನು ಕೊಟ್ಟೆಯನ್ನು ಕುಳ್ಳು ಕೊರಗೋತಿತ್ತಲ್ಲ, ಅದು ಇವಾಗ ಇಲ್ಲ. ಈಗ ಫೈಟ್ ಔಟ್ ಕೆಂಪಣ್ಣಮಯ್ಯ ಇವರೇನಾ? ಕೃಷ್ಣ ನೋಡ್ರಿ, ಅವ್ರು ನಿಮ್ಮ ಹೆಂಡತಿ, ನೀವು ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು, ನಾವು ಕಳ್ಸೋದೇನಿಲ್ಲ. ಕೃಷ್ಣ In order dated 21/1/2021. Past response by which sum of rupees 8,000, by which the sum of rupees 4,000 per month was ordered as maintenance to the respondent herein, along with the sum of rupees 8,000 towards the rent and a sum of rupees 10,000 towards the litigation expense and rupees 20,000 towards damages, compensation, etc. The petitioner has also challenged the order dated 16/7/2022 passed by the 6th Additional District and Sessions Judge at Court in Criminal Revision Petition 45/2021, by which the Divisional Court dismissed the revision and upheld the order passed by the trial court. Next paragraph. When the petition was filed, when the petition was listed for admission, the parties have settled the dispute and have filed a joint memo in terms of which, the petitioner has agreed to pay the sum of rupees 6,000 per month. It is 6,000 per month, inclusive of the maintenance granted in criminal miss 140 of 2015 before the principal family judge in court. Stop. The petitioner and the respondent are present in person and they admit the compromise. We of the same, this petition is allowed in part, and the petition filed by the respondent criminal miss bracket DV Act number 15/2017 is disposed of in terms of this joint memo. As a result, the respondent shall be entitled to a monthly maintenance of 6,000 per month, which shall include the maintenance of 4,000 ordered by the family judge, principal family judge including criminal miss 140 of 2014. Please sign from the date of the application before the trial court. Alright, so
The copyright act. The respondent is the manufacturer of one BD company was called BD by the name Mango Sultan BD. That works. They have been in the market. They are well known in the market, and I infringing of their mark. And that's a claim. It specifically stated that claim was that I have a registered trade name. At page number 42 months. Yes. Page number 42, paragraph number 18. They go on to say that I have got to know during the investigation that I have got a registered given by the trademark.
Subject to facts, please come to the release shortfall in the claim.
Yes.
The relief which is being sought for us is at page number 51. For permanent prohibitory injunction restraining different agents, representing stocks with all persons, leaving through or under them from using or imitating or passing off, that's the word maybe, passing off of the trademark or passing off the trademark of plaintiffs covered by the trademark registration for service. And also artistic designs plaintiffs by copyright registration. It is produced as document of doing in manufacturing, storing, marketing, selling of things. Consequently, they ask us if the relief for mandatory injunction. That's my prediction before the trial court.
The suit was filed before the commercial court.
Yes. The suit came to be filed before the commercial court. First condition before the commercial court was that section 12A of the commercial code act ought to have been followed, which apart doing the divergent views of multiple high courts, was settled by Patel Engineering, Patel Automation, whereby it said compliance of section 12A is mandatory. Because I have section 12. The institution, mediation, and settlement. The suit which does not contemplate any urgent injury shall not be instituted unless the plaintiff exhausts the remedy of the institution mediation. Accordance with such manner and procedure has been discussed by those papers and the this perhaps multiple divergent views were given by
No interim application. Was there an
application was 5 minutes. That was not considered.
whether an application?
Application came to be because I was marked as IA number 3 minutes. I take my loss to the authority.
What was the application?
Let's make it turn to page number 70 and extra E that I produced the entire order sheet. That's page 70. Only permanent injunction. Next page, page 71. IA 1 of 2022. That's page. Code of Civil Procedure.
There's an application for some interim relief.
The order is at page number 73. If my no prima facie case, ex parte, I didn't know the order was. That's my first intention. That section 12A ought to have been followed even before your filing of an application. Do not dispense because that's the law laid down by us. Second contention, because as I pointed out, page 42, they admit that I have a word mark. Because page 42, 5 of 18. If I have a valid registration under the trademark, there is a presumption that the registration is valid. Or put it otherwise, if I have a registration still valid, the registration is presumed to be valid. Now, that's when the presumption under section 31 is that registration is valid. Under section 30, they cannot institute a case of passing off against me. That's when I have section 21.
Where are the 2 marks? Where are the 2 marks?
They have admitted in the.
Where are the 2 marks?
It
should be viewed from the what you call eyes of a customer who goes to the market to purchase.
I have not produced the 2 marks here. Because
the test is whether it is deceptively similar.
Deceptively similar. That's exactly what is covered under section.
Whether you and I can be deceived, believing that that product is this product.
Yes.
That is all.
Yes.
That is a test.
That's a test. As per the standard of well, 27 minutes. Section 27.
Yes.
No action for infringement of unregistered trademark. no person shall be entitled to institute any proceeding to prevent or to recover damages or infringement of unregistered trademark. Nothing in this act shall deem to affect rights of action against any person for passing of goods or services as the goods of another person, or as services provided by other person or remedies in respect to their section 27 provides for common law remedy of passing of goods. Since this remedy cannot be availed against me because I have a registered trademark.
You don't have a registered trademark, you have only a word mark.
Registered trademarks when you're filing a
Correct, Mahesh Chaudhary can be a word mark,
It's a word mark.
but the way you present it
Yes.
with the color combination, that
I think that's
therefore
I would not be able to dispute on that. But I'm that was in section 30. What are the limits of section 30? Emails. The use of registered trademark being one, that's how it's being section 30. The use of registered trademark being one of the more trademarks registered under this act, which are identical or nearly similar. The exercise of the right to use that trademark by the registration.
yes.
That's my submission before this. If there's any problem which the defendants or the plaintiff has against it, the ideal course of action is not to file a suit for infringement, but go for rectification under section. Because that's the procedure of trademark. When a trademark is filed, four categories which comes the top box. One is graphical representation, another one would be a key dimension and a color mark. They also have not got a graphical representation. They also have got a word mark. What they have got is a copyright of the artistic design. That also I'll be able to show how after 50 copies are produced, they cannot sue for infringement. That's the copyright. In so far as trademark, they have a word mark, I have a word. They are operating in a sector called selling of DVDs. I am operating in a sector. And that's my geographic place. I am selling it in Mysore. They are selling it in India. That's my contention. So, in so far as any such activity, it's only under section and not others.
Please read section.
Power to cancel or vary registration and to rectify the register. Because I just pause here because after we file a trademark, you would be notified with objection either under section 9 or section 11 of the Trademark Act, which is either absolute or which can be cured. After we reply to it, or if there is no such objection, the trademark is actually published for 4 months on the register notes, a journal gets published. Because even after that, nobody objects. That is when I will be awarded a trademark. That notes will be entered in the register. And if any person has a problem with it, any agreed person, an application made in the prescribed manner to the High Court or to the registrar by any person, the registrar of the High Court, as the case may be, will make such order as it may be quicker or cancel or varying the registration on the ground of any contravention of the failure to observe provisions entered on the register in relation thereto.
Yes.
Thus, at the outset, section 9 would be applicable. Section 9 of the CPC mirrors would oust the entire jurisdiction.
Where does it oust?
Because I read the because I would resort to Commercial Goods Act Section 11, which is looked at as a part of jurisdiction of the commercial goods and commercial goods.
In section 11.
Section 11, because I agree. Notwithstanding anything contained in this, shall not indicate or decide any suit to any commercial dispute in respect of which is implied any law.
Where is it barred is what I'm asking. Where is it barred?
Yes, I am drawing my post from the word implied law. Section 57 is implied law. Thus, I have only tried to convince the law that the way the entire plane has been debated to forward is to combine. Thus, I not seeking for infringement. What they're seeking for is partial law, which otherwise they may not keep doing it.
Yes.
Because they hit by section 27 1 by on the face of it, and yes, because my mark is the registered mark, I can gain support under section 30E.
Please produce both the marks. I need to see both the marks. Without the marks, you know, you're just leading me nowhere.
Right about the release which that you get it after the data is registered. That is a verification because they not then.
Bother about 4 or 5. You need to see whether both the marks are nearly deceptively similar. If this is the case, seven will come. If you had sought for a word mark, the name of possibly Mango Sultana Bidis. If you had applied, if you had got a word mark for Mango Sultana Bidis, what you say is right. But here is a case where you obtain a word mark for Kai Sultana Bidis, and he has got a word mark for something else, and he's got a visual representation which is unique that you copy, according to him, that you have copied. So therefore, unless there is something to show, a case for rectification.
Into the foundation. The detailed results where they are not about saying purpose of the time you want to get. In the debate that a lot of people they have my transportation of plane. Now they get a little more of mega. The entire organ state. That's division fiction can be maintained every now the entire organ state. Now what is the stay of the proceedings before the commercial court.
Clarify and say that this order will not affect the order of injunction granted to the commercial. Learned counsel for the petitioner seeks time to place on record the word mark. Place on record the trademark of the petitioner as well as the trademark of the respondents 1 to 10. To see whether both of them are deceptively similar and whether a case for rectification under section 57 of the Trademarks Act is made out. At this stage, Kamala will learn civil counsel for the response 1 to 10 submits that this revision petition is filed challenging the order, rejecting and challenging the order dated.
The order sheet is signed by the
Order dated 9/12/2022, by which an application filed by the petitioner under Order 7 Rule 11A and B was rejected, and therefore rejected, but the petitioners have surreptitiously sought for the relief of stay of the order passed by the High Court on an application filed in the Order 39 Rule 1 and 2. Full stop. Next paragraph. The order dated as rightly contended by learned counsel, senior counsel for the response 1 to 10. This petition is filed only challenging the order dated 9/12/2022, rejecting an application filed by the petitioner under Order 7 Rule 11A and B of CPC. Full stop. There is no stay of the order dated. Please wait, please. Order dated 9/12/2022, so far as it relates to the order granting interim injunction in favor of the respondents 1 to 10. On IA number 2. On IA number 2. List on. Whenever you want. Immediately. Any Thursday 16. He is also happy. He has also got injunction. He is not a granted. Till the next day. Section BS. Dinesh Kumar Rao. Yes, sir. Huh? Yes, sir. Where's the complaint now? Yes.
Dealership in the execution procedure, if it has been executed, the dealership code. After judgment, dealership, the FIR can be filed. The police file should be reviewed. So this is like
Suit is decreed. What happened thereafter? The other side, Dinesh Kumar. Bill for file ID. petitioner is challenged an order dated petitioners challenge the sanity, legality and propriety of the proceedings initiated by the respondents in PCR number 60 of 2010 on the file of the additional civil judge, junior division and JMFC Antwal. Stop. The gravamen of the case of the complainants is that the petitioners, that the accused had obtained an agreement of sale and power of attorney, na? Agreement of sale dated 2/6/1988 in respect of a property belonging to them and had filed a suit in OS number 225 of 2009 for specific performance of the said agreement. Full stop. In the mean, full stop. The said suit was pending consideration. Full stop. In the meanwhile, comma, the complainants filed a private complaint contending that the accused had fabricated an agreement of sale and had filed a false suit. Stop. The private complaint was referred to the jurisdiction police for investigation under section 153 in terms of the order dated 27/8/2010. Full stop. Being agreed by the same, comma, the present 2010 full stop. Based on the said order, comma, FIR register ಆಗಿದೆಯಾ? ಆಗಿದೆಯಾ? Based on the above said order, comma, the jurisdiction police have registered crime number 29 of 2013 for the offences punishable under section 468, 469, section 34 of offences. That's correct. When this petition was taken up for preliminary hearing in B group, the learned HCGP submitted that a B report is already filed in the case. Therefore, no use, and therefore this petition has become infructuous. Full stop. The learned counsel for the respondent number 1 is absent. In view of the fact that the investigating officer has filed a B report, is yet to be accepted by the court. This petition is disposed of reserving liberty to the petitioner to challenge any further proceedings initiated by the trial court based on the B report. Because B report will accept that you challenge it, Mr. That will be on a different ground. Right, that will be on a different ground. Who called 17? Who was it? The court can do it. The court can do it. Why not? You challenge it, Mr. After the B report is accepted, you challenge. You always have one more round. Because this complaint is already gone. It's gone. B report is filed. Once the court accepts it, then we will consider file a fresh petition. Really, take your time, don't worry. Good. Page number? We will resolve about it. CGP separated. The report is filed. We already filed in the case, and that the trial court considered the protest petition filed by the complainant, and after recording the pre-summons evidence, has directed the jurisdictional police to investigate and submit a report. To stop. He submits that this order dated 2/12/2017 is not justiciable as the investigating officer is yet to submit his report. Stop this. What do you have to say? Please read whatever you want to rely on section 202. Good. Sir, don't go to the judgment. First, you come up with the facts. What exactly has happened? What is it you want? Don't jump to judgments just like that.
The complaint are not having any within the university guiding of the high court. Based on the file.
Yes.
I don't know that. Depending number 3 is it is the entire case of trading. And that we are trading in the extent of 4 acre 88, 4.8 88 acres. The third circumstance, two against being does not provide and break the business. So, experiment number 1 and 2 are not found within time. But later find IA number 5, fail to permit them to file the return. This code rejected the prayer of experiment number 1 and 1 and 2, which are unfortunately they are not part of them. The case of litigation. They are not enough. By already the ET was closed and we were taking that how 12 and 2 days. Yes. Both related to we could see certain it has not been this problem. So more or less the agreement about the
Let the police consider all this. Let the jurisdiction police consider all this. Next. No. This is started.
Not a request for loss of state. Page number 83. Page number 53. Your in the court constitute cognizance. The court said this court is not yet decided to take cognizance. Or
Where is it?
they refer the matter for investigation to the investigating officer. Therefore, at this stage, clear sanction. Therefore, further hearing of the matters officer are required to become necessary. Without the page 25 of the message of the intent. As per the order cost of this cannot be said that complaint is not reasonable. At the time of taking cognizance, the court, at the time of taking cognizance, clear permission from the court. At the time of hearing, the learned advocate for complaint submitted that the complaint be required for investigation to the ACB. From going to the documents produced by the complaint, applications filed by the at this stage, prima facie cognizance may not according to prima facie materials are available. Reference to the allegation made in the process. Therefore, the matter needs investigation. Now, across the reason, present complete of ACB Shimoga under CRPC. As per case the evidence is not there. The clear sanction in the online taking up this fact and 114 of Forster, not the other than that, he wants to investigate the allegations of the year 2011 and file the complaint in the year 2019, 2017, 6 years delay.
What is the nature of complaint?
Complaint below at page number 33 minutes. 33 FIR. ಫಿರ್ಯಾದಿಗಳು ನಮ್ಮ ಕರ್ನಾಟಕ ನಿರ್ಮಾಣ ವೇದಿಕೆಯ ಕಾರ್ಯದರ್ಶಿಗಳಾಗಿದ್ದು ಭದ್ರಾವತಿ ವಲಯ ಆರೋಪಿ ಉದ್ದಿಮೆಯವರು ಪ್ಲಾಂಟೇಶನ್ ಮಾಡಿಸಲು ಯಾವುದೇ ನೀತಿ ಎಚ್ಚರಿಕೆ ಇದೆ ದುರುಪಯೋಗ ಮಾಡಿಕೊಳ್ಳುವ ಉದ್ದೇಶದಿಂದ ನಮ್ಮ ಇಲಾಖೆ ನೀಡಿ ಇಲಾಖೆಗೆ ಪ್ಲಾಂಟೇಶನ್ ಮಾಡಿ ಹಲವಾರು ದುರುಪಯೋಗಗಳ ಕಾರಣವಾಗಿದ್ದು ಬೇರ್ಕೊಂಡ ಕೃಷಿಗಳಲ್ಲಿ ಗೊಬ್ಬರವನ್ನು ಪಟ್ಟಿಯಲ್ಲಿ
The next document is PCR 34. The allegation is respect to the earlier DFO. Right, value number 404. The company submits that the accused has filed the rest. So, it's not separate. The benefit. Ultimately, what is there against this accused? Nothing in the complaint. Now what is nothing in the complaint? It's not said anything. One more thing that they have. Forest only one more happy to get back to the other. Other most of money that is there to the visitor. How do you do something? This is the part. Let us see what is the complaint made?
Because at para 7, my lord, complaint submits that the illegalities of not appointing those as qualified contractors. It does for contract with the transparency entire contract. Very much. Forest reserves within the forest it's exclusively the property of forest. Who's to show the cost materials and paid and like this. The employees of the forest likewise the amount within the sector of the officials of forest. No new plantation to be made. They used to show the materials and this saplings having the formation of new plantations. Thus the cycle of practice to continue today. Like the present officials who are present tenure, case at ACS, Badrachari, Chandagiri division, and one article range. The above officials are particular with the accused as against the case.
You will sanction order. You will sanction order. Why did you make them as accused?
The complaint is being issued. What is that?
I'll complain here. GAT Girisha. There is not even a whisper against this accused.
Only semblance of merit when the commissioners.
No, you see how selectively is.
Because there is no complaint. But that is a curable defect of my submission.
As the Supreme Court says when Priyanka says.
But doesn't say. Supreme Court says that in such cases it should not be. Nevertheless, I cannot be wrong.
You want to initiate proceedings, you initiate on your own.
Because the complaint should be given to at least.
This is what Priyanka says. That.
Because saying the curable defect it doesn't.
Forget Priyanka, I am not even. On facts, what is there? Because this accused.
Then we will not signing the case.
But interest of all purposes. Agidya, admit interest of all further persons until disposal of this petition. Yes. Huh? ಅಲ್ಲ 10% ಬರ್ಬೇಕಲ್ಲ ಮಾರ್ಕ್ಶೀಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವರು ಅಡ್ಮಿಟ್ ಮಾಡಬೇಡಿ there is no representation for the respondent from discount by the last chance. Tejas N. Ahmad Pasha. Yeah, offense. ಹೇಗಿದೆ? There is no representation for the petition. Password ಬರೀ ಈ ನಂಬರ್ 2016 correct ಹೇಳಿ 2016 how long you want to keep it? Tomorrow. Any date is tomorrow. Then counsel for the petition system as a last chance respond. If you don't argue, we will dismiss it. I will make it very clear. If you want to continue, we will to the next set of hearing. Mahadevappa. Huh? Mahadevappa. What is the ground? So, you have correct. Was there sufficient funds in the account? If there is sufficient funds in the account, what you say is right. What is there to show that you had sufficient funds? Then 2017, you are still securing the information. That is a crucial. That is a fact that you have to, I mean, that is the instruction that you have to secure. Well, counsel for the petitioner should secure instructions whether the petitioner had sufficient funds in the account as on the date of dishonor of the checking question. Based on 14th as the last chance. Shiv Prasad YS. It is stated at the bar that the learned counsel for the petitioner has expired. Officers directed to issue appropriate court notice to the petitioner to make appropriate arrangements for their representation in the case, their appearance in the case. Sunil Kumar. Sunil Kumar. Illa. There is no representation for the petitioner as a last chance respond. Nagarajappa. Gaurav GK. Possibly. Yes. ಅದನ್ನ ಸೆಟ್ಲ್ ಮಾಡಿ ಇದು ಮಾಡ್ಕೋಬೇಕು ಅಂತ ಏನಿದೆ? The police should decide this. Please read the complaint. Well, if you send some messages outside with your modesty. No, messages ಬಗ್ಗೆ ಹೇಳ್ತಾರಲ್ಲ. Why? Photos ಅಲ್ಲ. What about messages? Forget photos. What about messages? ಅವ್ರು ನೋಡ್ತಾರೆ, ಅವ್ರು ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಆಗಲ್ಲ. 354 ಬರಲ್ಲ. ಇದು ಹಂಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸ್ಕೊಂಡು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. To do some mistake, you have to pay through your nose. Page 21. This is a problem. Nowhere they are safe. If you want to draw a precedent, you also settle. This is for Agala, right? But what about the other? The fine after close model, market. You're willing to pay a fine, appear before the court, pleading guilty, fine will be imposed, will be set off. Set off. So therefore, if you want to avoid that mark, pay it. Counsel for the petitioner is trying to explore the possibility of discount. Tomorrow granted a late extension to the next. She Ali. Rajendra Dixit. She Ali. This one. What? Counsel for the petitioner has framed a memo stating that the petitioner who is accused number 4, accused number 1 is CC number 13100 of 2016. Report this one's for court has expired on 14/6/2021. In view of the above, the criminal prosecution of the criminal proceedings against the petitioner / accused number 1 as abated. Is abated, madam. Number 60, Kiran Kumar, N. Devaraj. Not after next week. The request of learned counsel for the petition discount. Everybody wants an adjournment. I don't know when will you argue. I don't know. Ramesh P. Kulkarni. Issue what? Yeah.
60, my lord, I represent the counsel for the petitioner.
The case about Killa. Yes, sir. Where is the order of the appellate court? What has the appellate court done, sir? Not decided on merits. Suit is not decided on merits. On merits.
Against the order of remand in
Because read the order. Not necessary. Pay para 49 only. RE 282. The earlier suit is OS number 3034.
Yes, sir.
This is the first suit. What is the subsequent suit? Subsequent Antira. Which is the first suit, sir?
Earlier. But then we fight
1655 was earlier. 1655 was earlier numbered as something else. When was 1655 filed?
earlier for my statement. Why you saying 2006 was filed?
But earlier until the 3034, same court or different courts? Same number of same court. 3034 of 2006. That is a subsequent suit.
This subsequent, but decided.
3034. 3034. What are the issues there?
99.
Who are the parties in this? Who are the parties in both these?
These are the same.
To see if all the parties are there. Vairappa is Vairappa by LRs. Akkayamma. This is Vairappa by LRs illegal. Huh? Right. Where are the parties in OS number 1655? 1655 Delhi are parties. And who is this other one? Naranappa. Naranappa's LRs. In OS number 1655 of 2006 is not a party in OS number 3034. Yes, Mr. But no, I'm just asking you for sake of clarification, whether this Vairappa's children who are defendant number 5 in OS 3034 of 2006.
Yes.
Were they arrayed as parties in OS number 1655? Two parties are Akkayamma, Channappa, Niyappa, Srinivas, Ram. They're not parties. Similarly, in OS number 1655 of 2006, Naranappa's children are not parties in OS 3034.
Evidently, it matter of the
Degree. Where's the degree in OS 3033? Degree illide, sir. Where's the degree? No, none here ಮಾಡಿದೀನಿ ಯಾವಾಗ. Who was it admitted?
or dispose of illegal people. But we have sought for declaration that particular the alienation of a particular land is bad. But in that manner, they have taken a specific stand. And the legally the value of the declaration scholars, they do not only not very validity is there. And original proposal was Hanuman Kappa. Then he had proposals not the idea. But the original proposal is Hanuman Kappa. It belong to this family. The strict contention was taken that partition has already been effected. And
Between Hanumantappa and Venkateshamappa.
yes, it was not Hanumantappa. Hanumantappa had passed away. Second son Hanumantappa had passed away. It was a monument Kappa, his son. Monument Kappa acted on behalf of all the first wife and second wife. Then between Venkateshamappa. The specific condition was taken up, therefore this good property is according to them, they can follow to the share of Venkateshamappa's as partition has been effected. Therefore, the milestone got written. That was the contention. Actually, they proved the contention that partition has already been effected. But this my school was dismissed on the ground that petition had already been taken place and they are separate from this domain. Therefore, my lord, once the partition has taken place, second food for partition is not maintainable was my contention. Therefore, I filed an application. But I had no occasion to take a specific plea that the second the specific 165 is barred by investment data. But both these books are pending. Once my school was disposed of, I made an application for the event. Already it was clear in the earlier book that whether the family has been partition has been effected in the family or not. And on that issue, the trial court gave a categorical finding that partition has taken place. In that partition, therefore, my school is dismissed. They are going to be dismissed.
Why do they say that?
Issue number 4 is the 3 courts. The process to find it at page number 110.
Yes.
115. Issue number 5. Whether the second dependent group that the wisdom has taken place in February around 1949. Set
Who's the second defendant here? Krishnamma. Krishnamma is the wife of Hanumantappa. That is the third son of Venkateshamappa.
Validity has given in the degree in food also.
Krishnamma. What about the other defendants? Other children of Venkateshamappa. Have they contested? Yes, Mr. You are not ready. ಮತ್ತೆ ಯಾವ ಟೈಪ್ ನೀವು ಮಾಡಿದ್ರಿ ಹೆಂಗ್ ರೆಡಿ ಆಗಿದ್ರೆ ಹಂಗೆ ಮಾಡಿ. ಫೈಲ್ ಹಾಗೆ ಕುಡಿ ಕೊಡಿ ಪೇಪರ್ ಬುಕ್ಕೆ ಕುಡಿ ಅಂದ್ರೆ
Father-in-law, all this properties, directly between the parties,
this 1655 is filed by Venkateshamappa's children. What is their claim?
From another papa's time, and then that they want the partition.
Filed by only Muniappa's children and Rukkamma. That is Muddanna's wife. D7, D8. Yes. Suit is filed by the last son of
Then another couple and master in the water. All of them have to be done. In the Lord, the return statement in the Lord.
I three plaintiffs really. Plaintiffs and defendants constituted members of the undivided Hindu family. Plaintiffs are produced so and so.
Yeah, Hanumanthappa alias Appayappa. Hanumanthappa and Appayappa had two wives. They are Muriyamma and the Venkatamma. Venkatappa was the son of Hanumanthappa and Appayappa born to his mother Muriyamma. Further that Sri Narayanappa and Gopalappa are the sons of Hanumanthappa. Yes, Appayappa born to his wife. They are to Alpalvi Ramanya. Anjanappa, Venkateshan Ramesh, remains 1 to 4. Then we have to further respectfully submit that Venkateshamappa here continued. The second son of Hanumanthappa had 4 sons. They are Sri Uddarna, Krishnappa, Hanumanthappa, and Muriyappa. The first 3 sons of Venkateshamappa, that is Sri Uddarna, Krishnappa, Hanumanthappa, and Uddarna is the wife of Uddarna is the wife of Uddarna is the wife of Hanumanthappa. Relative number 1 is son of Venkateshamappa, who is the second son of Hanumanthappa. Relative number 2 is not because Venkateshamappa is the wife of Uddarna. Relative 1 to 4 are the sons of Venkatappa, the son of late Hanumanthappa, alias Appayappa, born in Muriyamma. And number 5 and 6 are the sons of Hanumanthappa, alias Appayappa. Second wife, Venkatamma. The dependents number 7 and 8 are the second and third daughters of Venkateshamappa, that is wives of Venkatappa and Hanumanthappa, who are the second.
I think, Bunny, please come to that relevant point. Now, plaintiffs say that they are still a joint family, correct? Now, what does the different number 7 and 8 say? What are the different 7 and 8? Have they filed a statement? Different 7 and 8 have not filed any statement. D5 has filed. Again, they represent this Hanumanthappa's family. So the release will take it some other day. Lord counsel for the petition, appellant seeks time. Vandana PL.
My lord, I represent the counsel for the petitioner. The charge sheet is under challenge, which my lord should kindly find on page number 9.
Number 9.
Page number 9 only. My lord, the offences imputed are 1 under Karnataka Open Place Disfigurement Act 1951 and 1981 under section 3 and 5. Mother, there is, my lord, IPC offences of 427 and 149. This particular act, my lord, the Karnataka Open Place Disfigurement Act, that this matter pertains to Tumkur. That act is not made applicable to Tumkur at all. That act, my lord, in fact, my lord, it is there. We had placed it with the file.
The Open Places Disfigurement Act.
Open Places Disfigurement Act nalli.
Karnataka Open Places Disfigurement Act 1951. Yeah. Geographical application is there.
Geographical application ಅದು ಫಸ್ಟ್ ಬರೀ ಇದಕ್ಕೆ ಮಾತ್ರ ಮಾಡಿದ್ರು ಆಮೇಲೆ ತುಮಕೂರ್ಗಿನ ಅದನ್ನ ಮಾಡಿಲ್ಲ. If your lordship could kindly have my lord section 1 of this act This act may be called as Open Places Prevention of Disfigurement Act 81. It shall, but then 1 clause 2, my lord, be deemed to have come into force in the cities of Bangalore, Mysore, Hubli, Dharwad, Mangalore, and Belgaum constituted under the Karnataka Municipal Corporations Act or under any other law on the 5th day of 1981. And come into force in the municipalities notified area sanitary boards
Tumakuru
constituted.
municipal corporation is there. Tumakuru is also municipal corporation.
Corporation is there, but he acted in a notify madilla allige.
What is the date of the offense? 2019.
How?
Then by that time, Tumakuru was a.
I am further respondent number 2.
Yes, Manjuna.
I have filed a memo on the 16/1/2021, and this act is amended in the year 2020.
Yeah.
And it
What
is
is
that amendment act published in Karnataka Gazette on 27/4/2020.
16
Along with the memo, I have filed the act and amendment act.
What does it say?
According to the amendment act, it is applicable to all the notified area. May I request to come to the page 7. There is an amendment act. Amendment of section 1 in Karnataka Open Places Prevention of Disfigurement Act 1981. In section 1 in subsection 2 after clause 1, the following shall be inserted, namely 1A. Come into force in any other area falling within municipal corporation area or larger urban area declared under the Karnataka Municipal Corporation Act 1976 or areas falling under the Bangalore Development Authority or any other urban development authority or any other local planning authority constituted under the relevant law in force from such date as may be notified by the state government. Kindly, next document, that is the notification issued by Urban Development Secretariat dated 20/12/2013.
2013, ಇದರಲ್ಲಿ offense ಯಾವತ್ತಾಗಿದ್ದು?
2019.
ಮತ್ತೆ ಹೆಂಗಾಗುತ್ತೆ? Come to Article 20 Constitution.
So, no, this corporation declared in the year 2013.
2013. Correctly, Act ಯಾವಾಗಿಂದ ಬಂದಿದೆ? University
Act came into force on 24/7/2020, but Act says from the date of notification.
No, I'm not on that. The amendment of this Karnataka Open Spaces Prevention of Disfigurement Act 2020. Amendment ಯಾವತ್ತು ಬಂದಿದೆ?
The amendment is on 27th April 2020.
27/4/2020.
And even after that amendment, my lord, there is no notification. This the Honorable Court on the last occasion did, my lord, specifically put a question to my learned friend. Even the amendment prakara torsodadrunu, this amendment, my lord, of course, this amendment came later. By then, my lord, the offence had already, it cannot be, my lord, applied retrospectively. Even with respect to this amendment, there is no notification by the government. The amendment only says from the date as may be notified. My learned friend was asked to produce if there is a notification which is not there.
Yes, Mr. Manjunath.
Kindly see first page of the amended state, paragraph page number 6, statement of objection and reasons. In the bottom, published in Karnataka Gazette Extraordinary number 153 in part 4 dated 27/4/2020.
So even then it is after the offense is committed, Mr.
After the offense, but it applies from the date when the Tumkur city becomes corporation.
How can there be an offense? It can't be an offense because it was not an offense.
Yeah, as per the Amendment Act, it is from the date when the city is notified as corporation. That is my argument.
The amendment bandid yavagindanappa? 27/4/2000.
Subsequent to filing of the FIR.
Then
subsequent to filing of the FIR.
But it was not an offense at that point in time under the act.
Because a Because corporation formed in the year 2013, it is retrospectively applicable. That is my argument. In the Amendment Act, it's not specified.
Section 3(5), 427, 149.
427,
Yes.
there is no ingredients, my lords. If I may take your lordship to the complaint. Complaint, my lord, should kindly find a case in a complaint is on page number. Charge is the extract ಮಾಡಿದ್ದಾರೆ, column number 7. My lords, may kindly have page number 15, 15.
49 ಬರಲ್ಲ,
149 ಬರಲ್ಲ, 427 ಬರಲ್ಲ.
427 ಬರ್ಬೋದೇನೋ.
ಇಲ್ಲ ಬರಲ್ಲ 427. My lords, may kindly have page number 21, my lord, the complaint. ಸಿ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ನಿನ್ನೆ ರಾತ್ರಿ ಅಥವಾ ಮಧ್ಯರಾತ್ರಿ ಯಾರೋ ಕಿಡಿಗೇಡಿಗಳು, ದಿಸ್ ಕಂಪ್ಲೇಂಟ್ ಮೈ ಲಾರ್ಡ್ ಈಸ್ ಫೈಲ್ಡ್ ಬೈ ಜಿಲ್ಲಾ ಕಾಂಗ್ರೆಸ್ ಸಮಿತಿ ತುಮಕೂರು ಟು ಡೈರೆಕ್ಟ್ಲಿ ಮೈ ಲಾರ್ಡ್ ಜಿಲ್ಲಾ ಪೊಲೀಸ್ ವರಿಷ್ಠಾಧಿಕಾರಿಗಳು ತುಮಕೂರು ಜಿಲ್ಲೆ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಮೈ ಲಾರ್ಡ್, ಮೈ ಒನ್ ಮೋರ್ ಲೈನ್ ಆಫ್ ಮೈ ಆರ್ಗ್ಯುಮೆಂಟ್ ವಿಲ್ ಬಿ 154 ಮೈ ಲಾರ್ಡ್ ಸೇಸ್ is an officer in charge of the police station. The information of the offence has to be given to officer in charge of the police station.
Yes.
Jilla police Varishtadhikari can never be, my lord, considered as the officer of the police station.
We'll see tomorrow for discussion.
Grateful. Great.
Yes, huh? Number? Yes, depends under the mindset mental side. Discharge. Yes, Mr. 370 angle.
Here different of this the case of
When there is a special legislation, 370 angle. Special of ಎಲ್ಲಿದೆ ಡಿಸ್ಚಾರ್ಜ್ ಎಲ್ಲಿದೆ? offense ಎಲ್ಲಿದೆ? ಅಲ್ಲ ಬಟ್ ವಾಟ್ 370 ಇರೋದು. You said that for the other offences you have been discharged. Where have been discharged? Mr. Where have been discharged? You said they are discharged.
Use the word discharge.
But you also don't use it. Where are you using it? MMDR offences, this is the court cannot, does not have the jurisdiction. Only 370 matter. ಆಗುತ್ತೆ ಹಂಗಿದ್ರೆ. Lalita Kumari.
having credible information.
What is the finding? Without registering crime, it was investigated, is it? Will you please show it? Page number 32. Ah. So page number 33 now. Just a moment. Just. ಫಿರ್ಯಾದುದಾರರ ಮುಂದುವರಿಕೆ ಹೇಳಿಕೆ ಅಂತಿದೆ. You're reading from the chart sheet. Huh? Where are you reading, mister? ಈ ಪ್ರಕರಣದ ಸಂಕ್ಷಿಪ್ತ ಸಾರಾಂಶ. Is that what you're reading? Page number 17. Was. Yes, mister. The petitioner has challenged the cognizance taken by the trial court in CC number, in special CC number 45 of 2017 for the offense 17 on the file of the Principal District and Sessions Special Judge District. For the offense punishable section 379 of IPC. The case of the prosecution was that on credible information received by the investigating officer that the accused were conducting illegal quarrying of red stone They visited the spot on 12/4/2017 along with the officials of the Revenue Department and found that the accused were quarrying the land in survey number 112/2 and 112/3, which was the Patta lands. Patta ಸ್ಥಳದಲ್ಲಿ the 112/3 without obtaining appropriate licenses and permissions, and therefore seized the equipment used for quarrying, and later registered crime number 46/2017 for the offences punishable under DR Mines and Minerals Regulation of Development Act 1957, under section 4, 4A, Karnataka Minor Mineral Concession Rules 1994, under section 3(1), 42(1), 43(2), MMDR Mines and Minerals Regulation of Development Act 1957, and under section 21 of the Karnataka Minor Mineral Concession Rules, section rule and section 379 of IPC. The trial court, a charge sheet was filed for the aforesaid offences. So the trial court, after considering the charge sheet and the materials enclosed with it, took cognizance for the offence punishable under section 379 of IPC, and consequently framed charge for the said offence. So being agreed by the same, the present petition is filed. Further, counsel for the petitioner's offence that section 379 was a cognizable offence. The investigating officer was bound to register a complaint before undertaking investigation or search or seize the equipment used for committing the offence. So we relied upon the judgment of the apex court in the case of Lalita Kumari and submitted that the consequent charge sheet filed by the prosecution, as well as the cognizance taken by the trial court for the offence punishable section 379, deserves to be set at naught. Now, to learn, HCGP on the other hand submitted that the cognizance taken was in accordance with law, and that the mandate of the apex court in the case of Lalita Kumari was not breached, was not violated. We submitted that upon receiving the information from the investigating officer was entitled to conduct a preliminary inquiry to ascertain whether the information received was true or not, and therefore, the prosecution launched against the petitioner is just and proper. I consider submission made by the trial counsel for the petitioner and the respondent. The complaint lodged was the complaint. The complaint lodged by the geologist, Mines and Geology Department, repeat, clearly discloses that they had credible information about unlawful quarrying in the land bearing survey number 112/2 and 112/3 of Kaltur village, where the accused were quarrying red stone. Full stop. Therefore, the jurisdiction police had information about the commission of a cognizable offence, and thus it was incumbent upon them to register a crime before undertaking investigation, more particularly when the information was received by the geologist. The concerned area will stop. The investigating officer was therefore bound to register a crime before undertaking any investigation. To stop that not having been done, and the seizure of the equipment used for the commission of the offence having been seized prior to registration of the FIR, all falls found of the judgment of the apex court in the case of Lalita Kumari, all proceedings against the petitioner deserve to be halted. That way of the matter, this petition is allowed. All proceedings against the petitioner in so special case in the so on the plate of so are all for Prashant, it is. Huh? No. Income proof ಇಲ್ಲ ಏನ್ ಮಾಡಕ್ಕಾಗ್ತದೆ ಇಂತಿ ಮಗಾತಾನೆ. The petitioner has challenged an order dated so and so, passed by so and so in criminal miss 3021 of 2014, by which the court ordered payment of a sum of rupees 3,000 each to the respondents herein as maintenance. The petitioner is also challenged the judgment of the Provision Court in dated 27/7/2017 in Criminal Division Petition 5014 of 2017, by which the Revision Court dismissed the revision and upheld the order of the trial court. The respondents 1 and 2 initiated proceedings under section 125 of the Code of Criminal Procedure or Criminal Procedure Court, claiming maintenance from the petitioner hearing. Stop. The trial court, after considering the oral and documentary evidence, held that the petitioner is capable of paying the sum of rupees 3,000 each to the respondents, and therefore passed an order directing payment of rupees 3,000 each to the respondents. A revision petition filed before the Division Court in Criminal Division 5014 of 2014 was also dismissed. The present petition is filed. Federal counsel for the petitioner submits that the petitioner had no known source of income. Therefore, payment of a sum of 6,000 per month would cause immense hardship. He submits that the petitioner was earlier a sales executive and was drawing a monthly salary of 10,000, and thereafter he lost his job due to the unit going sick. And a termination letter he was terminated from the services. Unit going sick, unit was closed. Unit was closed due to a lockout, and later he was terminated from service. He submits that the petitioner has now no source of livelihood, and therefore the impugned order passed by the trial court and upheld by the revision court being set aside. The respondents, those served with the notice of the petitioner, have not appeared. Having regard to the fact that the petition respondents are the wife and son of the petitioner, and also having regard to the fact that the petitioner was earlier a sales manager at an export house, it is impossible to accept the contention of the petitioner that he has no known source of income. So the petitioner is an able-bodied man, and therefore he is bound to maintain the respondent's will stop. Having regard to the having regard to the cost of living and the need to maintain the respondent need to maintain the education needs and necessities of the respondent number 2. The order passed by the trial court is just and proper, and therefore this petition lacks merit and the same is dismissed. Last time. Please read the company. Please read the company. Read it, man. Please read it. Mutyalamma, Mutyalamma.
ಅವನ ಸ್ನೇಹಿತ ಪಲ್ಸರ್ ಬೈಕ್ ನಲ್ಲಿ ಬಂದು ನನ್ನ ಮೇಲೆ ದಾಳಿ ಮಾಡಿ ನನ್ನ ಕಾಲಿಗೆ ಜಾತಿಯ ಬಗ್ಗೆ ಕೀಳು ಜಾತಿ ಇದೆ ಎಂದು ಶ್ರೀಮತಿ ಶ್ರೀಮಂತರವರು ಈ ವಾರ್ಡಿಗೆ ಮುಖ್ಯಾಳ್ ನಗರ್ ನೇಮಕವಾಗಿದ್ದರಿಂದ ನನ್ನನ್ನು ಎಲ್ಲಿ ನೋಡಿದ ಬೈದು ನೀನನ್ನು ಸಾಗಿಸಬಹುದು ಎಂದು ಇದರಿಂದ ನನಗೆ ಭಯವಾಗಿದ್ದು ನನಗೆ ಏನಾದರೂ Then she said, what she was ಶ್ರೀಮತಿ ಸುನಂದ ಮತ್ತು ಅವರ registered on the complaint is registered on the state. Because what a statement which is registered on the state and ಏರಿಯಾದ ಕೌನ್ಸಿಲರ್ಗೆ ಎಲ್ಲರನ್ನು ಕಟ್ಟಿಕೊಂಡು ಸಾಲಿನಲ್ಲಿ ನಿಂತಿದ್ದ ನಾನು ಸುನಂದಮ್ಮ ಉದ್ದೇಶಿಸಿ ನಾವು ಮುಂಚಿದ್ದೇವೆ ನಾವು ಪೂಜೆ ಮಾಡಿಸಿ ಮೇಲೆ ನೀವು ಸಾರಿ ನಮ್ಮ ಹೋಗಾಡುತ್ತ ಬಾಯಿ ಮಾತಿನ ಜಗಳ ಗಲಾಟೆ ಮಾಡಿ And even the charge sheet witnesses, Prashant Subramanya, they are
ಆಗಿರೋದು ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು ಎಲ್ಲಿ ಹೇಳಿದ್ರು ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ರು ಹೋಗಿದ್ದಾಗ ರಾಮಯ್ಯ ಸಮಾಧಿಯ what is this? This is change. To clear deviation from what you said. ಹೋಗಿದ್ದಾಗ ರಾಮಯ್ಯ ಸಮಾಧಿಯ ಬಳಿ ಲಾರಿ ಸ್ಟ್ಯಾಂಡ್ ನಲ್ಲಿ ಬಳಿಯಲ್ಲಿ ಶ್ರೀಮತಿ ಸುನಂದ ಮತ್ತು ಅವಳ ಪುತ್ರ ನನ್ನ ಮೇಲೆ ಜಗಳವನ್ನು ತೆಗೆದು. The place of incident itself is different. The first complaint. What trial? If it does not result in a conviction, we will not waste time. If the case is not going to result in a conviction, we will not waste time. As for your own case, it is different. Stand, ಲಾರಿ ಸ್ಟ್ಯಾಂಡ್ ಬಳಿಯಲ್ಲಿ place of the crime itself is different. ಹೋಗಿದ್ದಾಗ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದು ಎಲ್ಲಿ ಕರೆಕ್ಟ್ ಇಲ್ಲ. ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದು ಕ್ಯೂ ನಲ್ಲಿ ನಿಂತಿದ್ದಾಗ ಸಮ್ ಅಲ್ಲ. The place of the crime itself is different. Interim step in disposal of this criminal petition. Madam, this is just a 2018 matter.